Thank you. Good evening. January 13th, 2026 at like 7:35. We'll call the Willington Zoning Board of Appeals meeting to order. Roll call. Mark Lucinda.
Jack T.
Bill Blair. Bill Plan. Okay, application and receipt, legal notice. ZBA 25-4, 335 River Road. Public hearing for appeal by the Foundry LLC on a cease and correct order issued by the zoning agent alleging the presence of violations of zoning regulations pertaining to work without permits, approvals, the presence of unregistered vehicles, the accumulation of debris and other materials, and unpermitted land disturbing activities. Zone designed commercial. MBL 330-17-00 owner, Foundry LLC. Now, whoever's going to speak on behalf of the Foundry will stand up or introduce yourself. I don't care if you sit down or stand up. Introduce yourself and tell us what this is about.
Chairman, would you like me to give a quick overview in terms of procedures? Do you have these kinds of appeals very often? Most of the towns we represent, they pretty rarely have these appeals. So I was often asked to give a quick overview.
If you would, that would be, thank you. I would appreciate that.
My pleasure. So
I'm sorry.
That's okay.
No. The one of the rights that functions that your board has, but you don't often have to exercise it, are appeals from enforcement decisions. And although it's couched as if it's an appeal, you try to decide whether the enforcement officer was right or wrong. It's really a do-over. They have a right to come before you, the applicant, having appealed the decision, and have a hearing before this body. And you now step in the shoes of Mr. D'Amato, and you hear all the evidence tonight, and then you make your own decision. It's going to be based on the evidence that's all presented in the four corners of this hearing. You don't necessarily have to go back in time and decide whether Mr. D'Amato should have considered something different, or should he have reviewed it differently, or this or that. Often ZBAs will, to set the stage of what the hearing is about, because it's an appeal from a decision, will often have the enforcement officer go first and make a presentation of the information that led the officer to make its decision, and then give the floor to the applicant to then present its reasons for wanting to reverse it. But there's no rule to do it that way. You don't have to do it that way. I tend to find it makes some sense because it gives context before the appellant, but the appellant should have the last word. After the appellant speaks, obviously the members of the commission could have questions of any of the presenters. It is a public hearing. You're entitled, or the public's entitled to be heard. You as chair get the rule as a parliamentarian on things to make sure things stay relevant. If someone wants to talk about something that really isn't related to the question before you, which is based on the evidence that that's being presented tonight by the enforcement officer, by the appellant, and by any members of the public, whether or not the appellant is in violation of the regulations. That's really what it all comes down to. And you get to make your own decision on it and your own orders on it. So that's basically the premise. So ordinarily, I would recommend have the enforcement officer give the background and the decision, then turn it over to the applicant. But it's really up to you, up to the chair's prerogative in terms of how you wish to proceed. And then, periodically, I might try to help out. Things seem to questions arise or whatever the board might have. So I'm here representing you in your interest and advise you, not the enforcement officer. He has a place at the table, obviously, as does the applicant, but I'm here to guide you. You have 65 days. Well, the public hearing opens tonight. You have 35 days to keep the public hearing open. these hearings tend not to need, unlike a complex site plan application where there's lots of plans and presentations, it doesn't usually need an extension, but it's possible. You have 35 days to close the public hearing. Once the public hearing is closed, you have 65 days to render a decision. And you can also confer with me. Cannot, unlike situation, maybe a typical meeting, where the zoning enforcement officer might be talking to you about a variance application, for example, on an enforcement matter. Once the hearing's closed, you shouldn't hear from Mr. D'Amato or the appellants, but you can confer with me as counsel of the board. So that's essentially the overview. If anyone has any questions, I'd be happy to answer them. But that's sort of the how-to of an appeal on one of these orders. They call it a de novo appeal. That's what I'm calling it, a do-over. That basically is a blank slate. Everything gets presented tonight, and then you make your decision. And it's not whether or not Mr. D'Amato was right or wrong. It's your own decision on whether or not the regulations are being followed.
Well, thank you. That being said, that would clear up a lot of thoughts in my mind, because it really doesn't say what the violations were or how they came. So if that would be okay, I'd like maybe have Mike D'Amato tell us what took place, and then we'll follow up. Thank you. Thank you.
So normally I would move there, but I need to manage the Zoom, so I'm going to sit here. So I prepared a memo, which is in the packet, just kind of to go over everything and kind of outline it. The actual cease and correct order is in there as well. So I kind of broke it up to provide some context, background. I then went into some of the regulations and we'll go on from there. So I'm going to kind of skip going through the first piece because Ken covered it, but essentially this appeal was filed on November 25th, 2025 in response to the cease and correct order, which was issued to the property at 335 River Road on October 27th, 2025. So I'm going to skip sort of the rest of that because you've heard about it. So next paragraph, I kind of tried to provide some context and background. And I'm just going to read it so that I don't have to paraphrase. It'll make it 3 times as long. There is extensive background and history pertaining to this property and the property owner. It is worth noting that enforcement actions initially began in 2022 related to the large number of vehicles which had gathered on the property. Both the notice of violation, warning letter, and cease and desist order were issued citing violations related to the presence of conditions which constituted a junkyard. Since that time, our office has had several conversations with the property owner, both via email and in person, about the status of compliance for this property. On several occasions, the owner has indicated that he would bring the property into compliance, including removing the vehicles from the property beyond the single quote Sprinter van and relocating them to parcel in Waterbury. This statement was made in an email on 4/15/2024. During the August 20th, 2025 Planning and Zoning Commission meeting, the property owner further indicated that he was in the process of removing the vehicles from the site, some of which he was in the process of selling. Additionally, staff has traded numerous emails with the property owner and or his representatives on several issues, including the lack of compliance at 335 River Road. While the prior actions are not specifically relevant to the matter currently before the board, I believe it demonstrates that the property owner has been aware of the town's zoning regulations as they apply to these issues since 2022 and has stated on several occasions an understanding of what was necessary for compliance. So there are 4 regulations which are cited in the cease and correct order. And I guess a distinction that I'll make is I did not issue a cease and desist order. Cease and desist order is telling him to just stop. I'm not asking him to stop or the property owner to stop. I'm asking the property owner to take a specific action, remediate the violation. So we want activity to occur and for that activity to move the property into compliance, which is why the order is a cease and correct order. So the third section includes the requirements or the regulations for each of the sections cited in the notice. As I mentioned, the specific section numbers are different. You'll see like the 315 number, which you would not have seen before, and the number in the letters, subsections. we have since gone through a codification, and the commission has adopted a new sort of body of regulation. So the section numbers are different than back in October when this initially started. The 315 number is now the part of the town's code that covers zoning. So the first section, it involves permitted and prohibited uses, which states which prohibits a building from being erected, converted, enlarged, reconstructed, or structurally altered in a manner as to be designed, arranged, or intended for any purpose other than uses permitted in the zone in which the building is located. So again, as I said, the condition constituted a junkyard by the town zoning regulations, and there's no permit for a junkyard. We don't allow junkyards in that zone. So this is sort of a broad statement basically saying you can't do things unless they're permitted, and you have to more or less go through the process as per the zone that property is in. The next two sections specifically cite prohibited uses in the design commercial zone. So the first one, just B, prohibits two or more vehicles from being located on a property which are unregistered or not in a condition to be legally operated on a public highway, as they are defined as a junkyard per 301, which is prohibited use. So we have prohibited use in the DC zone. It says junkyards. The definition of junkyards is defined above. So I've included sort of all that in one. So there's the presence of vehicles which are unregistered and or not in a condition of being legally operated. The qualifier that a vehicle is registered does not take it out of potentially contributing to a finding of there being a junkyard. This needs to be operable, legally safe to be legally operated on a public highway. The second piece to that section prohibits the accumulation of debris, discarded materials, household trash, vehicle parts and pieces, etc., as they are again defined as a junkyard. And the last section, 16.03A1, is erosion sedimentation control plan, which prohibits earth moving, grading, or land disturbing activities, including the removal of trees or vegetative cover, until an erosion and sedimentation control plan has been reviewed and approved. So one of the things that I observed that caused me to feel like issuing this order was necessary to begin with was the presence of, or the sort of newly observed equipment on the property in the form of some sort of what looked like rental earth moving equipment. So those, as I get into later, that was sort of what led me to see that activities were still occurring on the property. And again, as you can see in the photo, sort of that finding that there was sort of substantial activity creating a condition where we had erosion and sedimentation control needs that weren't being met. The regulations in their entirety I've attached to the in your packets. So in the next section, I have addressed the claims raised by the appellant in their application. The first, they've stated that the only activity occurring on the property is the removal of brush and weeds. So the below photo aerial is from October 27, 2020. Sorry, the photos included in the October 27, 2025 order show a total of 3 pieces of earth moving equipment on the property: a skid steer, mini excavator, and a backhoe. These machines are purpose built, not intended for brush clearing or removal of weeds. And the included photos show piles of dirt as well as a newly established driveway or path with vehicle parking on the north side of the building, well beyond any activity necessary for brush or weed removal. The aerial below is from April 9th, 2025, which again shows significant earthwork beyond simple brush removal. You can see some of the areas which are sort of shadowed that are sort of a kind of cuts and fills. Where there are some substantial changes in grade. We're not saying that the ultimate activities can't occur, but we're saying you need to have an E&S plan in place. We need to have a chance to look at this before these activities should be happening. Number 2, all vehicles on the property are registered. While registrations for vehicles which were on the property in 2022 were provided at that time, no supporting documentation has been provided in response to the order issued in October. Further, per the most recently updated assessor's records and grand list, which I confirmed with the assessor, there are no vehicles listed on these properties as of the date of the order. As of the date of the order, there were 12 on site. So again, these vehicles having been on site for several years, they should be showing up on the town's grand list as being part of that. That's publicly available information. We can't run plates or do any of that stuff. I don't go on the property or try to figure out what it is. If a vehicle is registered, it is in accordance with Connecticut state law as far as when a vehicle comes into the state and it's on a property for several years, it should show up on the grand list. So that was, again, information that is in support of sort of my position. Further, as I mentioned, the town zoning regulations as referenced above require that the vehicles be registered and in a condition for legal use on public highways. The mere fact that a vehicle is registered is not the qualifier for compliance. Some vehicles are missing tires or other parts or are covered with tarps, which does not demonstrate the ability for such vehicles to be legally operated on a public highway. Lastly, the Connecticut General Statutes requires vehicles to be registered in the state within 60 days. So again, I'm not the arbiter of that because I'm not a state police, I don't run plates, but the state has laws in place which say when a vehicle comes here and you come here, it should be listed on the grand list in the municipality that it exists in. And so if these vehicles have been on site for multiple years, we would expect to see those on the grand list. And that's part and parcel of how we would verify that these things are sort of meeting the regulations. Number three, all building materials have been moved inside the property. The photos included with the cease and desist order or cease and correct order depict materials which are located on the exterior of the property at the time the order was issued. Actions taken by the property owner after the issuance of the order are not germane to the matter currently before the board. So, at one point in time, they asked me to perform an inspection and confirm compliance. I did an inspection. I did not find compliance. And their request was that I retract the order. And I told them that compliance was not on the property. Compliance had not been achieved, so I couldn't retract the order unless they wanted to enter into sort of a violation abatement agreement where they would agree in writing to do certain things within certain timeframes. At that point, we would then have retracted it. So things that happen after the fact, again, do not put me in a position of being able to pull the order back. They had appealed the order, which as Ken explained, is telling you that I issued it incorrectly or in error. I have no control over things that happen afterwards. My decision to issue the order was based upon the status of the property as of the time that the order was issued. And at no point in time did they reach out and say, we're going to move things up into the building or off the property. Can you give us more time? So sort of, this does not really speak to what I was reviewing when I had to do the inspection. The last component, there have been no filling, excavation, earthmoving, or grading activities conducted on the property, and thus there is no issue of accelerating erosion, sedimentation, or stormwater runoff. The owner of the property has merely removed brush and invasive vegetation. My response is essentially see above. I feel that I've sort of addressed that there's something more going on there than just removal of weeds and brush. In summary, a cease and correct order was issued to the property owner because the regulations do not allow the following: if the storage registered or not as a primary use in the DC zone. That's the first section. Storage of two or more vehicles which are unregistered or not in a condition to be operated on a public highway. The accumulation of debris, starting materials, etc., or earth moving, grading, or other land disturbing activities. As outlined above, the duty of the ZBA is to determine the validity of the order based on the regulations and circumstances as they existed. The ZBA is not making a determination as to the compliance as the time of the hearing or based upon actions which may or may not have taken place since the appeal was filed. So based upon the above, staff's position is that the order should be affirmed as written based upon the fact that the appellant has not provided any substantial evidence to demonstrate that the finding of the properties are not in violation of the zoning regulations.
Mike, is this pretty thorough? Okay, thank you. Yes.
Want me to call up here?
Sure, if that's what you'd like to do.
I think just so he'll get me done.
Is this all right here?
Yeah, the Michael.
Okay.
Yeah.
Good evening, Commissioners. My name is Rob Bolito. I am an attorney with the law firm of Willinger and Busey. Our office is located at 1000 Bridgeport Avenue in Shelton, Connecticut. We are here representing the Foundry LLC, who is the owner of 335 River Road, and Mr. Christian Vega, who is here tonight. He is the sole member and also the trustee of Seed and Grow Trust, which is the manager member of the Foundry LLC. As Mr. D'Amato pointed out, on October 27, 2025, he issued a cease and correct order alleging several violations on 335 River Road. We respectfully disagree with the CZEO and request that you sustain our appeal. As to the legal standards, which counsel advised you before, you're aware that you have the authority pursuant to your own regulation 315-21.01 and Connecticut General Statute Section 8-6, subsection A, subsection 1, to hear and decide appeals where it is alleged that there's an error in any order by the CZEO. Say that 10 times fast. The cease and correct order is clearly an appealable order. As counsel has advised you, this is a de novo hearing, which means that you cannot assume that Mr. D'Amato's actions were correct. You must hear this appeal as if he wasn't involved. You are essentially the arbiter of fact here, and you must make your own decision about the appropriateness. As to the reasons for the appeal, there are many reasons why we believe the cease and correct order is inappropriate. There are, number one, technical and legal reasons, and number two, factual reasons. And I'll start with the technical and legal reasons. First of all, the applicable standards cited by Mr. D'Amato in the cease and correct order are incorrect. There is no section 4.1 in the regulations. It was cited as section 4.01, permitted and prohibited uses. The correct citation is section 315-4.01. As to section 1603, there is no section 1603 in the regulations. The correct citation would be 315-1603. Then section 5.03.01.05.07. Sounds like Morse code. Trash, debris, and vehicles on the property. Correct citation is regulation 315-5.04E2F. Section 0.503 pertains to the Design Neighborhood Commercial Zone, the DNC. This property is not located in that zone. It's located in the DC zone. Now, going to the factual reasons for overruling the order. If at this time, with the chairman's permission, I'd like to ask my client, Mr. Vega, to come up so I can just ask him a couple of questions in response to the cited violation. Sure. That'd be all right. Speak. I'm going to go through these one by one, and I'll ask Mr. Vega a question about particular violations that were cited, and hopefully that will shed some light on the situation. First of all, the enlargement or structural alteration of a building. Did you do that?
Absolutely not.
Inoperable or unregistered vehicles. How many vehicles are on the property currently?
As of today, there are 7. 2 of them are inoperable. One is missing a tire. It's right next to it, and that can be fixed. And then the other one is was bought purposely for an action. So we are looking to get rid of that. So,
and the other 5 vehicles are registered.
Correct.
I would also point out for the commission's consideration that you heard about the fact that certain vehicles didn't show up on the grand list. That doesn't matter. They could be taxed or assessed in a different town. And Mr. D'Amato does not have the authority as the DMV does to run plates, as he mentioned. So the fact that they don't appear on the grand list is not indicative that these are not properly registered vehicles. So please consider that. As to debris, would it be accurate that at this point there is 1 skid left with 2 pieces of plywood on it as of the 7th of this month?
correct.
The dumpsters have been removed.
We're still waiting for the dumpster at 335 to be picked up, but it has been scheduled to be.
When is it going to be picked up?
They said within a week.
Okay. You're cleaning up the property currently.
Currently, yes.
Okay. Now, as to the disturbance of the land without an erosion and sediment control plan, the regulations do not define what a land disturbing activity is. It just mentions it. Section 315-1604 defines grading as, quote, any excavating, grubbing, filling, including hydraulic fill, or stockpiling of earth materials, any combination thereof, including the land in its excavated or filled condition. Chris, I'm going to ask you some questions. Did you do any excavating?
We did at one point, and that was in working with the health department to remove a failed septic system that was imploded in the property. And the chief sanitarian and the prior health department official, Holly Hood, who retired, all knew and all were present and were aware of the situation. It was an emergency repair to remove a septic that was hidden in the property. And as we drove over, a piece of the front property was caving in. At that point, that was during the summer. After that, no additional work was done.
Okay, so you did that in conjunction with health.
Correct.
Did you do any grubbing?
No.
Did you do any filling?
Other than that area, no.
Okay. Did you stockpile any earth materials? So what did you do on the property?
That was that. Basically, we removed the weeds. When I first bought the property, it was tick infested, so we tried to maintain removing weeds. The machines that were there have brush hogs on them, have rock crawlers, take any big debris out. But it's basic maintenance, and that was it.
You didn't cut any trees on the site.
No trees are cut down.
Okay. And you said that the chief sanitarian confirmed that nothing had been done. That was Ms. Swanson.
This is Glenn S. Swanson, correct?
Okay. All right, that's all for now. Thanks, Chris. Provide a little.
I'm sorry, before
I apologize.
the question goes away. The vehicles that you just talked about and how they've been removed now, what was the status of those vehicles on October 27th? Because it's my understanding that that's what we have to look at here today is what was the situation on the day that the cease and correct order was issued, not anything that's happened in between. So what was the status of vehicles on October 27th when the cease and correct was issued?
Right. So what I will say is that even prior, the first initial, reach out that the zoning official did, when I first bought the property, he missed the fact that we had submitted a 2-page document with all of the documents supporting that the vehicles were in fact registered. And he came back to us asking the same question. At that point, they immediately stopped their cease and desist at that point in 2022, I believe. The vehicles that were on the property were still registered, but we removed it because we were trying to comply with taking out our personal storage from this site in order to develop it.
There was more than two,
Of
right?
course, yes.
Okay.
No,
and
more than two, yes, but all the other ones were operable and registered.
all of those vehicles, I drove by there today. Those vehicles are operable and registered.
Other than two, correct?
Yep.
Yeah, they came from across the street at one point, we moved them. And, we're going to tell later, but we were repairing work across the street.
They sure don't look operable to me.
Well, they are, and they can move.
Can I ask, where are they registered?
New York.
New York?
Some of them, one of them is in Massachusetts for a property we have out there. 3 of them are Connecticut, out of Shelton, and the rest are out of New York.
Don't have any of the registrations with you? I mean,
No, but we are willing to submit it, after this. But yeah, absolutely. I mean, we did it once before. The day I bought the property, I got a cease and desist. The day I bought it. And I went to the town and said, what the heck is this? There was another gentleman working with Mr. D'Amato at the time, who's no longer with the planning and zoning. And they walked us through what they observed. We gave them 2 pages of scanned documents. In New York, you have a 2-year registration, you can renew it online. And in New York, you also have inspections. So we were compliant then, we're still compliant now. And, we have not been taking, more of an approach prior, simply because we had no movement to develop the property. And that's what we're looking for now, is to clean up the property. Even though we are compliant, we are going to move the rest of the vehicles and clean it up.
I'm not so certain how you can say you're compliant if there's more than 2 vehicles. You're allowed 2, you're not allowed 12.
Sure. 2 are inoperable. That's what the regulation states. They have to be registered. In order to be compliant, they have to be operable and registered. Only 2 are not.
But you can't have more than 2 vehicles on the property. Am I reading the regulations wrong?
That's not my understanding.
Not mine either. There's no limit. I mean, think about it. If you're living in a house, if you have more than 2 cars, it doesn't make sense that you could only have 2 cars on a property at any one given time. So I think that's a
I'm not
literal,
talking about residential zoning, I'm talking about.
even in commercial,
Design commercial.
even in commercial, it doesn't make sense that you would have a limit of 2 vehicles on a property. I think that's an overly strict interpretation of the regulation with due respect.
Okay. Thank you.
One last thing to provide a little bit of context before I conclude on this. When Mr. Vega bought this property, and I'm going to allude to it again when we come back for the variances on both 331 and 335. This was a dilapidated mess of a property. Tick infested is an understatement. My client actually got bit to the extent he had to be hospitalized when he was trying to clean the place up. It was an eyesore. It was a magnet for vagrants and for squatters and illicit activities. And I'll get into more detail during the variance part of it, but he's been trying to clean this place up, and it's been a Herculean task. He's invested a lot of time and a lot of money to try to address these things, and frankly, to create a more safe and health conscious property. Health and safety issues were rampant with this property before my client took it over, and he's done his best to try to get it cleaned up so that it's no longer a threat to public health and safety. So in conclusion, for all these technical, legal, and factual reasons, I ask you to overrule the CEO cease and correct order and sustain our appeal. This property is located in the gateway to West Willington and should be redeveloped as soon as possible. That's why we have filed the 2 variance applications that we will hear next. My client wants to redevelop this property and turn it into something positive and productive for the town. Thank you.
Questions?
You have some evidence of, you said, vagrants and some other illicit activities in property, and was there police reports and such?
Yes, in fact, when my client bought the property, he had the state police come out because he saw some suspicious people going in and out. In fact, there was a robbery at this location a couple of years ago. The state police inspected, and they found, first of all, people who shouldn't have been there were trespassing, vagrants. They found evidence of drug use, crack pipes. They found heroin needles. They found evidence that there was prostitution being run in this and also 331. Evidence by condoms on site and basically a list of massage services that were available. Bad stuff going on. And this was confirmed by Troop C, the trooper who came out to inspect the property.
And when was that?
When I bought the property at 331, within 3 weeks, we broke it into twice. And once we had troops in there, it was the second week, so roughly first or second week of February, prior to the young man who drove into the building at like 9 a.m. And if anyone would recall that, UConn student on his phone. Around that time, Troop C came in to cleaning it up, and opening up drawers and finding all this mattress in the basement, sex toys, etc. And Troop C basically backed up with hazard equipment, backed up all the crack pipes and needles, and took no effect. So roughly about February, 2 years ago, February 13th or right around there, second week of February.
They also said that there were several regular criminals on their watch list who they identified as people being in and out of this building. So this was a real danger to the community. And my clients worked really hard to clean it up and make it into something productive. So I just want you to have that context when considering our appeal. Thank you.
Okay. I'm sorry, Bill, go ahead. I was going to say, how much of this order has been complied with or moved forward on since it was issued? I drive by there all the time, and you had a crew of people cleaning up the whole site. Saw the dumpsters gone in front of the building, looks a whole lot better. How much of this is being taken care of that it would make it void anyways.
So as of 331, we don't have a cease and direct order. It's 335 across the street next to Duncan. And so Duncan itself, we are actively still moving vehicles. I have a property out of town that we're going to relocate the video. But as you know, it was heavy snow the last couple of weeks, so we were able to get that done. That is in process. We're looking with no vehicles there whatsoever. And, actively continuing to we have 2 approved permits on our location. So that to begin and clean up and painting of the property and make it more visually appealing. But, weather condition is now, obviously we have to wait off of it.
So this order doesn't stop you from doing any of that, does it? Is this cease and correct or whatever, it doesn't stop you from moving your cars. It doesn't stop you from cleaning the site. It doesn't stop you from organizing and taking care of everything. You can still move forward with your painting of your building as long as you pull regular. I'm just trying to wrap my head around it, that if this were to stay, you're gonna outlive it or outfix it anyways, correct? I would assume.
So that's correct. And I will point out, though, that while it may not impact his day-to-day operations, obviously the threat of fines and further orders are in play. And we again go to the point that this was improperly issued. Whether it's impacting his daily business or not is frankly irrelevant. This is improperly issued in the first place, and that's why we're appealing.
Any other questions? Anything?
I'm just looking at some of these pictures, like from last October versus Section 8. I don't see much improvement. I have a picture here from last October of the building at Duncan. There's a bunch of vehicles to the right of the building. I have a picture here that I took this afternoon at 2 o'clock. The same vehicles are still there. There's 4 of them. Nothing. Really don't see much of an improvement going on here. Here's some more buildings, some more vehicles. And here they are again in October. So nothing has happened in the last couple of months. Mr. Vega, I saw on Facebook the other day saying that all the vehicles would be out in a couple of days. That was about a week ago or so now at this point.
Yeah.
Are you really making an effort to clean up this property? It's been an eyesore for quite a while.
I understand that. And we are. Again, I just want to reiterate that the vehicles being there are compliant. We are moving them at a good rate from 100%. There was notation that there was a tarp on one vehicle. Well, the tarp is because we couldn't close the sun before we can fix that. But that is also, of course, Cayenne GTS, and it's not great to have people knowing what kind of cars I have sitting there, especially because Troop C has been to the property to locate the vehicles missing out of the converters happen at night. And 4 of the vehicles, including the Sprinter van, has no power converter. So be fair, I'm also taking fee, but I am trying. And again, even though they are compliant, those vehicles are going to be removed.
Is there a timeline?
Remove those vehicles?
Yeah, I just didn't know
Yeah.
how you see your future.
Good question. Yeah, I mean, they would have been removed over the last 2 weeks because, we had solid ice. And Frank Motors and the other companies that are doing towing for me couldn't not get out there. We have a letter from Frank Motors. They couldn't even move the RV across the street because of the mounds of dirt that are completely iced out. They can't get around. So we have commitments made prepaid to move these vehicles, but it was unfortunately to the left.
Well, thank you.
You take, move the RV across the street, so you're gonna put it on the other front?
No, we're moving them off the property. But we need a tow company to do that. I've went and hired a local company to do that for us, which they can't at this point. Especially the RV, which I inherited. But they can't remove it because of the mounds of dirt that are solid ice surrounding the place.
Okay, Alex, you mentioned the dirt, vehicles aside, I was interested in. You said there was a failed septic that, and you removed basically all the vegetation, including the shrubs around the property that would have retained the soil, in my view. Well, the other excavation that you did, it looks to me to be, and I was in the trades for a number of years, a lot more than just weed removal. I understand ticks are a problem, but there are many ways to approach them. So I just wanted, the extent of your equipment usage on the property, how do you explain that? And this is one of the points.
I believe we've already addressed that. And as I mentioned, the chief sanitarian for the town, Lynn Swanson, did a walk through of the property and confirmed that nothing substantial had been done. That this was just brush clearing. It was the type of activity you would expect on a raw site. But this was not anything that would rise to the level of excavation. And again, made that representation and stick by it.
Did the sanitarian, excuse me 1 second, did the sanitarian present such a report? Because the sanitarian doesn't have any jurisdiction over what's land disturbance activity. They deal with the public health code. Is there something that she decided to render opinion about whether something involved?
I don't know that there was a formal opinion. What I know is that she walked the site because of the issue with the septic. Now, in terms of, the dirt that was involved because of the septic system collapsing, I don't know what that is or is not in her jurisdiction, but the septic certainly is. And because of the tank collapsing, dirt had to be moved in order to address it, because you can't have an open, pit. That's a potential liability and an attractive nuisance.
Can you identify for me for the property, where was that septic system located? Was it up on Route 32 or was it down below?
Yeah, I don't know.
The 35 feet in front of the existing structure in front of 335. Exactly 35 feet.
Okay, in front of, so facing on the Route 32?
Correct. So there is a driveway access to the property off of our right of way for Duncan, on the easement for Duncan. And 35 feet from the foundation of that existing property was where the septic was.
Yeah. Oh.
I'm sorry, go ahead.
Thank you.
Okay. Is there any water in the back of that property? I kind of, looks like a swale. It may not be at all. Looking at the satellite view, it kind of looked like a waving line around the back of the property that comes off of the neighbor's property.
If I could just ask for clarification, when you say water, you're talking about like a body of water, like a river?
No, I'm just talking about
standing water.
Water that looks like it would move, whether it be with excessive overflow or whatever. And it may not have looked like, whatever I saw when I looked at the satellite image, looked like there was a line across the back. Nothing back
I
there.
believe, just give more points of context. I believe when they developed Duncan, the entire property for that foundation was renovated for the site work, because it's mostly sand, and it looks like it's engineered. The entire area looks like it's purposefully treated. So no wetlands, no standing bodies, water, debris, or any other side.
Okay, so none of the debris, none of the material would ever wash off, have to get past the railroad track. Is that what I'm in?
Yeah, there's a dip that was engineered probably by either whomever maintains the railroad or the property prior.
Maybe that's what I saw.
Engineered Duncan, yeah, there's a dip and then it goes up, and then there's ENS control for the railroad tracks.
Okay, I think that dip may have been what showed up on that map. Okay. Okay, now in the audience, is there anybody that would have any questions?
How many votes does this take to overturn the CC correction?
4.
So it has to be unanimous because there's only 4 members of the ZBA. It has to be.
Correct.
It's the same as with variance. 4.
I get it, but usually there's only 4 members, so it has this. Usually this is a 5-member board. Right. So if you're telling me this has to do it, this has to be a unanimous decision.
There are no other members. Even if we pushed it to another meeting, these are the only members. We don't have alternates, and we still have a vacancy for number 5.
We used to put on a disinterested party to the ZBA, not if we were lacking.
I don't think that Ken can speak to that, but I don't think that would get you to allowing one no vote.
No, you need an appointment for an alternate or appointment for the fifth person, one or the other.
Bob was waving at me for quite a while now.
Bob Shabbat, 17 Jared Sparks Road. I would just like to say that the owner of the properties has come to planning and zoning this fall, 3 or 4 months ago, promising exactly what we've heard tonight. And looks the same. The only thing he's done is put some primer on the old antique building. That doesn't tell me that he's really serious about changing what's down there. Thank you.
Ralph?
Okay, here we go. Ralph Douglas, Willisville Road. As a former member of planning and zoning, I'm going to speak to this issue. I'm going to speak to this property. One of the things I've noticed with the attorney here is we're kind of confusing 331 and 335 because I'm not aware of any police activity on 335. There may have been. I know there's been police activity on 331. That's clear to a lot of people in town. I've lived here my entire life. I know this property much better than Mr. Vega and a lot of people in town. The septic tank we've been talking about is from a previous residence that existed before 2005 when Repco put his antique business in there. Repco went bankrupt. The bank foreclosed. B&M Realty held that property since 2005. Mr. Vega's owned it for 4 years. And what has he done with it as far as cleaning it up? Not much. As far as ticks go in Willington, ticks are a fact of life, folks. Get over it. They're going to be there. Whether you clear the brush and the weeds or you don't, they're there. I know, I've been bitten by them many times. Okay? I'm in support of Mr. D'Amato and his actions on this. I got one other minute. Okay. I'm clarifying. I need to clarify. I'll give you my letter supporting Mr. D'Amato.
Mr. Chairman, my apologies. Could the speaker identify himself for the record?
Ralph Lewis.
Ralph Lewis.
Thank you.
Thanks, Brian.
Thank you, sir.
You're gonna have this. I just want
It's fine.
I don't think I've got anything additional to add. As far as registered vehicles, state of Connecticut, when a vehicle is housed here, they're supposed to, and if they're operable, they're supposed to be registered in the state of Connecticut, not in the state of New York, not in the state of Massachusetts. If they sit in town for more than, Mike said 60, I believe it's 90, I'm not sure. We can double check that. They're supposed to be registered in the state of Connecticut. If they're not registered in the state of Connecticut, then they're part of a junkyard. I'm sorry. That's it for now.
Thank you. Should we enter this into the
Right,
record?
mark it as exhibit 1.
Thank you. Thank you, Ralph. Anybody else have anything to add?
Mike McCoo, First Selectman. I just wanted to share for the benefit of the record and for the applicant, or I guess the appellant in this case, Mr. Vega and his team, and for the benefit of the public, that it has been my desire, and I've expressed to Mr. Vega directly in 2 meetings we've had face to face, to support development, to support moving forward. I think we all, being in this town, were concerned about the condition of the property previously, and we are still concerned about the condition of the property. So if there's a way to help him move forward, I want to support that. I met with him at my office. Well, I'll back up one. First in September, previous to me being elected, I met with Mr. Vega and building official and sanitarian to review the current state of the property. We had a very good tour of 331, talked a lot about Mr. Vega's plans. I admire his imagination and ideas that he wants to try to bring forward. But we had, even at that moment, a similar discussion to what we're hearing tonight. The town wants to see it move forward. The townspeople want to see it move forward, but we have to follow process. We walked through the building. We looked at electrical systems that had been basically ripped out of the walls that had been removed, structural changes, new structure being installed, plumbing changes. He showed us all of these items. The building official was there. I'm trained as a building official and a fire marshal, and we had a discussion about the building permits. There were not permits for any of those things. There still are not building permits for those activities to be happening. So we had a conversation about that. How do we move forward? Let's get Mr. Vega on track. Let's get this process moving forward. Okay, we're going to follow the regulatory process. We're going to get permits. We're going to get moving forward. We're going to give him the opportunity to get before various boards or approval processes and see what the regulations and the property and the plan can sustain. Great idea. That was September. I got elected in November. I took office on the 18th of November. Mr. Vega had reached out as soon as I was elected and asked if we could meet. I met with him on November 20th here in the office, and we had again another very good conversation. We reviewed all of the stuff I already just shared with you, and I again reaffirmed, and he has made the point of saying, Mike, you looked me in the eye and shook my hand and said you would support moving forward. And I did. With the caveat that it has to follow process. This is process. I, in my role as first selectman, have been in conversations with Mike Tomato, with the building inspector, with the health department, not in an effort to stop progress, but in an effort to determine where we are and how we try to get progress. I was aware of the orders the building official has issued, and I have been in support of those. I was aware of these orders, although they happened previous to me being in office, so I had no role in approving them. My position still is that in an effort to protect his opportunities as a property owner, but also protect the town and the neighbors and whatever else from a misapplication or a misunderstanding or whatever it might be of the zoning process, which in my mind is sort of the good fence that helps good neighbors. I have supported these efforts to move forward with ratcheting up the appropriate enforcement to make sure that we can corral this and bring it around. Part of my responsibility not only is to Mr. Vega and that he sees proper process, but that the townspeople are protected by the process, and that the people who come to me and complain about the condition of the property are heard also, and that their right to protect it. And last, to concerns that Mr. Vega has expressed, I feel like I have a role in trying to protect the town from liability. And that could either be from failing to do our processes of enforcement or from doing them improperly. And I am aware that Mr. Vega is concerned that our enforcement has been too aggressive. I have given that very careful thought as we moved on. I have signed on to everything that has happened since I've been in office because I believe it is the correct. And I would not approve it if I thought it was onerous or risking the town's liability by taking those enforcement actions. So my hope is that that process can continue. This process can be upheld because I believe it is how we get to the proper place, which is any property owner being able to apply, present an idea, even if it's an idea none of us are familiar or comfortable with, and we can see if it can work. So I would support these orders staying in place because I believe they are the correct process. And when we can get to the next steps, I will very much continue to support Mr. Vega's efforts for development in the proper procedure. Thank you.
Thank you.
Thanks, Mike.
Anybody?
I had one point, Ralph, to this again, Village Hill Road. That barn was permitted when Repco Design opened his EMTs, whatever, design center. His design center was at 331. Their retail sales was at 335. That barn was specifically approved as a drive building by planning and zoning when the initial special permit was issued for that operation. It's never intended to have the potential to be developed as a residence. There is There was no water, no septic. As I said before, the septic was a consequence of the dwelling that was on that property before Jeffco developed it. It was merged with the lot that now contains Dunkin' Donuts. There's a unique history of Dunkin' Donuts, but I won't go there. The thing that disturbed me the most watching this property at 335 was the invasion onto the property, the lot to the north, the clearing of brush on that property. He went on someone else's land and cleared brush. I don't know if he got permission from the DOT to do that, but the evidence is obvious. If you look at the aerial photos and you compare them to the property lines, he invaded the property that we wanted. Now, all of that said, I'm not an opponent to developing this property. But I do want to see things done in the proper order, as Mr. McCoo has outlined earlier, or just now. It's appropriate. Go through the process, but don't buy a piece of land and you can do anything you damn well please and not get a permit. It just doesn't work that way. I've been slapped. Other people in town have been slapped for not getting a proper permit. And I've won. Not a big deal. Although the commercial, it's a little more fun. Thank you.
Yes.
Phil Bedell, 12 Red Oak Hill Road. To appreciate the effort that the fellow is putting in. I was just curious, since he's been here 4 years, I was wondering whether or not he's up to date on town taxes.
Probably not. Christian? Can't talk to her.
That I don't know. I don't know if we're that. I really don't know if that's part of our hearing. I'm sorry. It's a legit question for you, but it's probably nothing that we can handle or bring into our meeting tonight. So I'm sorry about that. But
I just thought it might demonstrate, a tendency or an attitude. I'm truthful.
Is there anybody online? I see okay. Any other questions? Any other input? Yes?
I
can't.
19 Birch Meadow Lane. I've lived here for 25 years. I thought I heard the property owner say that currently 4 of the vehicles on the property do not have catalytic converters because they've been stolen. Is that correct? If so, then they're inoperable. That supports the junk driver.
Okay,
Thank you.
yes, thank you taking that into consideration. Can
I make a couple of comments if we're done with the public?
Actually, may I request the opportunity to rebut some of the comments?
And you'll have the last word too, for sure. So you both should have.
Certainly. So if Mike can go first and then you'll finish.
Yes.
Finish. Okay, thank you.
So I just want to touch on a few things. Number one, I think I covered, but maybe if I didn't mention, the regulation numbers are not incorrect. The town went through a codification of all of the town's code, including the zoning regulations, which became effective December 22nd. So the regulations that were in place are not what are currently on the books. We went through a reorg, but we didn't change content. So the context, the content of what is in there is almost exactly verbatim, but the specific numbers have changed. I've provided that information to them through their various applications, tried to make it clear, given them all the documentation because we were going through this process. And so I understand it's confusing, but the current code is not that code.
So essentially, Mike, what you're saying is these numbers that are on your cease and correct order
Are the old code.
are the old codes.
The 315 is the new code.
Okay, and so the new codes are available.
It's online, yeah.
But
But the content is-
corresponds to your actual.
Right.
Cease and correct.
The content is the same. So things that were prohibited are still, we did not, and I can show you the legal notice. The intent of the entire review was not to change content. So the section numbers changed, but what they said, not. So the other thing, and I am not the health department, I can't affirm this. I wish I could give you something to show the sequence. But there was a discussion about how they had to crush a septic tank and they had all this approval from the health department. I don't think there were any approval to abandon the septic system. The documentation that the health department has provided repeatedly is that they have no documentation of septic ever being on the property. So there's nothing that talks about abandonment of a septic system. The only thing that they talk about is there's absolutely no record of it. At one point, Lynette's letter says, you know, there is no approval or record of septic being on the property, yet your plan shows a septic pit. Question. Also, this idea that this stuff happened with Holly Hood, the former sanitarian, she's been retired for 2 years. So anything shown in my aerials, which I listed today, Holly has not been employed by EHHD for quite a long time. So that work, even if it was a lot consultation with or whatever with Holly, there's like an 18-month gap between those two things. Just because I think it talks to the sequence and almost sort of speaks to sort of the town's intent. The prior enforcement action, he said he acquired the property and he got a cease and desist order. He acquired the property in April of 22. The cease and desist order, which was issued by Chris, former assistant land use agent, was issued in November of 22. We can't issue the property owner a cease and desist order in the future. I only know an owner once it's filed on the land. So we are not somehow aware of the property owner the day that they acquire and close, and we're preparing all these things. We also issue a cease and desist order, unless it's a major issue, after a notice of violation. So there was a previously issued notice of violation. There's been a lot of discussion about intent. I said, this is going to happen. There was snow. And I'm not speaking to what has been said previously, but the review of this order is about what is, not about whether or not the applicant's commitment to doing something in the future it does not have any relevance. Whether or not they're going to remove everything, whether they're going to do everything according to the regulations as of the moment we leave this building, has nothing to do with the status of the property when the order was issued. So, I think that's really important because there are implications to you deciding that this order should be overturned. You are essentially saying that we were incorrect and that the property is not in violation. So I want to be sure that we don't get caught up with, well, he's going to do these things, he's done some other things, and he sounds like he's got the intent to move forward. That may all be the case, but using that as the basis to decide that the order should be overturned is telling staff that those items are compliant. So if none of those things happen, we cannot continue enforcement. So it may seem like a small issue or it may seem petty, but I think it's in the context of where we have gone for the last 4 years. I think it's important to not sort of get focused on that commitment to do things. I would suggest you not accept the statement that the vehicles are registered. If it was as he is correct, when he provided registrations in 2022, we did not continue enforcement. Why would we? Their issue was registrations, he provided. So if it's as simple as providing us with a 2-page letter showing that all the vehicles are registered, why has that not been done? We are here with many people, multiple attorneys, online, in person. We've got all this documentation, but no registrations. So I would really hope that you don't just take that as being the case. If that is in fact what is going on, then fine, great, they're registered, they're operable, wonderful. But I do not have the flexibility and certainly fall under a high level of scrutiny with what decisions I make. And so I cannot operate based upon someone simply saying verbally, yeah, these are registered. Yeah, I'm going to do this, right? So we have to use evidence, and there's been nothing provided to the board concretely to show that they're registered. It would seem to me like that would be the easiest thing to do. And it certainly had it been provided to me prior to tonight, that issue would have been resolved. It's a very simple, here's a copy of some stuff, as he has done before. The other thing that I want to come back to, which is the purpose of my initial 401A permitted prohibited uses. There is no use of the property. The applicant has not sought a staff level or commission level approval to use the property. So whatever is happening on the property, why the vehicles are there, again, there's no connection to use of the property. there is, unless it's a farm, there's nothing that's just an as of right that doesn't require you to do anything with the town. So whether there's 2 vehicles, 10 vehicles, whether they're all registered, whether 2 of them are operable, aside from all that, the fundamental use of the property has not been established. There is nothing that has been sought by the property owner that would then require that 1 or more vehicles simply be stored there. Vehicle storage is not a permitted use in the DC zone. So when you try to get to why all these activities are happening, you step back, what's the use of the land? There isn't one. The last thing approved was the last use, which was what, 20 years ago? So I think I want to sort of underscore that. The other thing that I want to mention is at one point he indicated that the reason that the tow company couldn't come in the last couple of weeks was that there were mounds of dirt that were iced over. But previously they said they didn't do any earth moving and that it was just removal of weeds. Well, what are the mounds of dirt from? I mean, they're shown in the areas. But again, we have traded the better part of 60 emails. I have dealt with the property owner, multiple attorneys. I have provided guidance, given information. We have done everything in our power to offer a solution. If there was one, I certainly would not have chosen, as much as I love you all, to come here and do this for no reason, right? This doesn't benefit us in any way. There was no alternative. And that is why we didn't issue one for 331, because I did not see things happening on that property on the exterior to make me feel as though an understanding of moving towards compliance was not in place. The additional activities after the notice of violation, after all the conversations, after the presentation of planning and zoning, sort of brought me to a place where we understand the violations. We've had these discussions. I've dealt with the property owner, with the attorneys. We've had complaints on the property. I have no choice. We're going to have regulations. It was sort of a willful violation, which is ultimately why I issued it. I think that speaks to all the things that I will leave it there.
Thank you.
I'll be brief. We got some other things to speak to. As the zoning board of appeals, you have to make your decision based upon substantive evidence, substantial evidence, not matters of conjecture, not matters of opinion, even if those opinions are founded in some life experience. That's not your job. It is to make your decision based upon the evidence and the facts and the record that is established black letter law in Connecticut, Laughlin versus the Planning and Zoning Commission of the town of Bethel. So a lot of what we've heard has been simply opinion and conjecture and feeling and emotion. It's not fact. You got to base your decision on the facts. So I just urge you to do that, please. That's all. Thank you.
Thank you. All set. I don't know if I'm inclined to leave the public hearing open until we get the registrations. That would be, so they would be in place by the next meeting. I don't know if any other questions would come up from us for the, for the attorney or whatever, but I would be inclined to leave the public hearing open on this. I don't know if you.
I agree.
I think so too.
Yeah, I would agree. I have a couple questions. So the appeal is saying that looking to retract the cease and correct order. But in the reason for appeal, there's more or less saying that they've complied with everything that order. So, this is why I think we should leave it open, really decide whether the order was issued correctly with the codes or it's not about whether he's complied with the order or not, right? It's whether it's retracted or not.
And that would be as of April when it was issued. October when it was issued.
Yeah.
Okay. Yeah, so I would like to. I would like to leave the public hearing open. We have 35 days.
In addition to vehicle registrations, I'd also be interested in seeing that some kind of documentation showing that all vehicles are operable. To our friend's point over here, if 4 of them are absent pollution control equipment, that makes them inoperable. So we would like to know if they're operable or not.
Mr. Vega would like to address that if that's all right.
Sure.
I know that everything I'm about to address is more of just the town getting to know more than anything else. But I'll try to touch up on as much as I can. Catalytic converters being removed all pre-ignitions. It is a known fact that criminals that seek to steal catalytic converters, the older the better. So the ones that were taken were all pre-ignitions, unfortunately, but that's the fact that it is. And as you know, as those vehicles are New York State registered, the emissions cutoff time is, I believe, 2010. But either way, those catalytic converters don't make the vehicles non-operable. They just make them loud. You ever heard the green one go off? Sounds like a horn. But either way, so let's just kind of settle that and as a fact. The other cases are, thank you, the gentleman giving some context on the septic tank. When we discovered the septic tank on 335, it was lacking a cover, and we saw a reflection. It was raining. We thought it was stormwater. We reached out to the health department, Chris Buter. We told him we're going to dig it up and let him take a look at it. So it had stayed open for probably close to 8 months prior, and I think there was some conflation on where there was Holly Hood's involvement. Her involvement was percolation tests taken when I first bought the property. Her involvement had nothing to do with the septic. She thought there was no septics and no wells. We have found 2 wells on the property, a third well that's in question on the property line, and which you'll see next. And then she said, well, Hollywood said, if there was a septic, you might be able to grandfather it in, but this property's been here since around 2000, which it was right around 2000. So when we found this septic tank and we found that it was imploding and the ground was falling within it, we uncovered it. We reached out to Chris Buter. He was supposed to come take a look. By the time we reached out to Lynette Swanson for follow-up, she said, well, where is it leading to? And so we further pulled that up. It looks like whomever had this property prior had tried to reverse the septic flow because there was a PVC pipe coming from the outside of what would have been the leaching field side going directly to 335. 335 had a spout up in the ground that led to the PVC, which we also did exploratory demo to find out where this was going. We cameraed it and did all that. We have since removed all of it. I could have, and in discussions with Lynette Swanson, I could have said, hey, it's already connected. We inherited this. Let's hydro patch the entire septic tank or leave it in place. I'm a construction professional, all right? So I didn't want to go that route, and we did the right thing. We removed it. We removed all the pieces. We videotaped it. We sent documented records and images to Lynette Swanson. At the time, I was living in Shelton. So an hour and 20, 30 minutes to get out here was not something that I could do on a daily basis. I was developing, as a consultant, I was developing a project in Fairfield, massive project out there. So when we had time, when Chris never got back to us that he actually took view of it, observed it, confirmed it that it was destroyed, we went ahead and said, you know what, I can't leave this pit open. Get an excavator in there, bang it up, get rid of it. That's what we did. And we sent that out to Lynette Swanson, and we showed her that based on where it was on a legacy survey, Young was absolutely correct. It did house a previous dwelling that was in the area of the right-of-way for Duncan. And at some point, someone tried to reverse it because it was a single compartment septic tank. Someone also fed a well that is covered underground that needs to have a riser put on it, fed a well directly to that property. So whomever had done it, also Lynette Swanson weighed in and said it was probably trying to be done under wraps and illegally. So we did not leave it in place. We removed it. And so we were doing the right thing. There's always ways to get around it. And do this long enough. So that's my point. And to speak on context, those vehicles, they're not meant to be a disparagement to the community. I tinker. I like the vehicles. I like collecting them. But they don't need to be there if there's a reason to develop it, right? They don't. And so, yes, I have not taken a strong approach because I have not been in the neighborhood. But even then, the approach is, if they're compliant, why am I being asked to move them? So it's really just a burden of matter. If I had a reason to move them, if there was some forward movement, then absolutely I'd move them. If they were non-compliant, absolutely I would. But the fact is, why am I being burdened to run out there and move a bunch of vehicles because they're an eyesore? Fair enough, I agree, they might be an eyesore. It's opinion versus fact and versus what is allowed. And also, to the point of all this, I think that me wanting to move them and having come to the, at least on Zoom, to the ZBA meeting prior, I stopped all work. When I let this gentleman come into the property and review what we did, absolutely nothing at that point. We shored up a falling first floor from 331, which is 105 years old, and it was imploding. We did exploratory demo to remove some sheetrock. We didn't remove any structural components to the property, and we cleaned up the property.
It sounds like you added structural components to the property.
We added shoring, yes, and purposefully
Permit for that?
emergency shoring for a floor that's falling in is emergency work. So
Do you
even when
expect
we
that?
even when we wanted to do a permit, which we were advised, go get a permit for demo, we decided, you know what? We were having so many back and forth, so many unfair, overreaching communications. We decided, don't do anything. Leave the crew off the site and wait until we get a use. So we did absolutely nothing other than cleaning. And at 331, I still actively have a state permit from the DOT and a local permit that is for work outside of the property. Now, that is a whole different subject, but some of it's in here. And all in, anything that we did inside, we let both our first selectman, Lynette Swanson, and the building official know we had worked to cut off all the power. It's not Con Ed, Eversource had locked out and tagged out all of the electrical. So all the panels that were actively feeding power have never been removed. There were panels that were left there for whatever reason that had actually no feed lines to them. Those were hanging off the walls, but they do not power. They were probably just left there out of laziness during construction. But as of today, zero work has been done on that property. Zero work has been done in 335. We have committed zero extra loss of money to a property that we don't have a use for. So one of the people here asked, well, why didn't you do anything since then? Well, because I've been dealing with hell and back and actually being able to do something there in the first place, including getting permits rejected. Why do several of my permits get rejected? Because there was no agreed upon use. Even when that work was applied to do interior work, had no bulk increasements, had no anything to do with the exterior, our permits were getting denied. So I will say we tried to do several, I think 4 or 5 of my permits got denied. Internal work, stuff that should have been allowed just to help structurally make sound. What if I was just a developer that wanted to flip it, right? If I came in here and said, you know what, I don't want to seek a use. I just want to make sure that this 105-year-old property doesn't fall over, make it that it was hit by a car. I mean, we had some issues, hit by 2 cars in the last 2 years that I bought it. So all of that, I could have just maintained it, made it structurally sound, and sold it. Sold it off to another guy who was living there that had a rat, long rat. But I did it. I stopped all work. So people are asking why? Why didn't you fix it? Why didn't you return? Because we tried. We were met with opposition, and we stopped. And all work has been stopped. Other than having guys go there and move around more material to make the outside look better, maintenance, we stopped. Our construction crew is no longer there, and has not been there.
I have 2 questions.
Sure.
335, you mentioned excavating. That sounds like excavating, which you were told not to.
We had to excavate the septic tank.
Well,
Prior to the involvement of zoning.
It's excavation. And so you were digging around.
This is-
understand.
Yeah, there was no stop, cease and desist over that.
Property, but
whatsoever.
you said you were denied permits. There must have been a reason that you were granted the permit.
Yeah.
So.
The reason was there was no use. There was no use in play, right? And because there was no use, it stopped all interior building.
I believe we're getting a little far afield here.
I'm addressing what's on the agenda, so I just
We
need.
haven't gotten to the variance, the use variances yet. This really isn't
Oh.
relevant to the discussion about the appeal. So just respect.
I understand.
Thank you.
Thank you.
decision is we'll keep this appeal open.
Yes,
At what point do we, does the board have any discussion? We have to wait for the next public hearing?
yeah, what you do is
Yeah, you should wait till after the hearing's over. to start the
think about what you heard, think about any other questions or anything that you would have, or anything that would pertain to that you may need to ask legal advice on. And then coming the next, continue the public hearing, we'll discuss and see about the registrations and whatever else was there.
Point of order, Mr. Chair. With respect to the public hearing that we just had, I would think it would be appropriate for the board to make a motion to continue that public hearing so that you can cease.
We haven't gotten to that yet.
Okay, I'm just wondering if you're going to get to that point.
I will get to that.
So we can clearly embark on the next agenda.
I will, thank you.
Sorry.
No problem. Thank you. Okay, I'd like to have a motion, ZBA 25-4, 35 River Road.
Can I interrupt? Because I want to make sure that we know our dates, because for when you're continuing it, just so that because this is a special meeting. So your next regular meeting, I believe, is February 12th. So does that work for everybody? Because we need all of you to be here because there's no replacement. So February 12th is a Thursday.
Yeah.
Second Thursday? Does that work? Everybody's available?
Well, if it's not Valentine's Day, I'm good.
You're close, but not there.
Yeah, I'm back on the tenth, so.
Because we're going to be right around that 30 days. So if we are going to have any concerns about not, then we're going to need an extension. So we're all
Good with that?
I am.
Yeah, I believe
I am also. Thank
So
you.
if you could just include that in your motion so that it's part of the minutes for anybody who reads them, we'll all know when the next meeting will be.
And there won't have to be any publication.
At 7:30?
Thursday, February 12th, 7:30.
This would, I will entertain a motion, ZBA 25-4, to continue the public hearing scheduled for February 12th, 2026. And
I'll second.
So
all in favor?
Aye.
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 Okay. Thank you. We'll move on. Glasses off again. ZBA 25-1, 31 River Road, public hearing for a variance request for, from 315-4.22, 315-5.04B, table 5.04, and 315-9.02A, 315-9.03A, and 315-904 to allow for mixed-use development containing 6 residential units and a restaurant use not otherwise permitted in the zone. Zoned design commercial, MBL 30-1600, owner 33 River Road LLC. Okay. I guess if you'd like to tell us about your project. Yeah, we got a lot of digging into.
That's for sure. Appreciate it. Again, for the record, Rob Bolito, Willinger and Busey represents 2 owners here, same basic person. 331 River Road LLC, which owns 331, and the Foundry LLC, which owns 335. Again, Christian Vega, we represent the sole owner and manager of 331 and trustee of Seeding Grow Trust, the manager of 335 River Road. Since we're asking for variances for both rather than do them individually, I think it would be better time-wise and for your consideration to just kind of, give you the lowdown on both, if that's going right with the commission.
We say both, I mean, the
We've only opened the public hearing on one.
Yeah.
Can we open it on both so I could discuss both, or would
That
we
I'd
need to
like
do it
to-
one at a time? I'm trying to save the commission some time to be efficient here.
Like to turn to the attorney to ask
I mean,
if
they're
that's
two very
acceptable
distinctive
practice.
Very
properties.
distinct
I mean,
properties.
when you open up
And
the
very
second,
distinct plans,
you open
too.
up the second hearing, I think you can make reference to some of the things you might have needed early when possible, but it seems to me, my first reaction is yours, that they're very different properties and they should be handled in two hearings.
I'm happy to take them one at a time if that's.
Yeah, I would rather do that.
Okay. So we'll start with 331 then. That's what's open, correct?
Yes.
Okay, great. So we're seeking use variances to permit mixed-use developments on 331 River Road. Ultimately, 331 River Road, with your approval, will be developed as a restaurant with 6 residential units. There will be 3 studio units on the first floor. There will be 2 one-bedroom units on the first floor, and then 1 2-bedroom unit on the second floor, and then the restaurant. We propose it to be developed as sorry, not doing 335. So we're specifically seeking variances of the following sections of your regulations. Section 315-4.22 prohibits having 2 principal uses on a lot in the DC zone. One of the proposed uses is a dwelling. We're seeking a variance for a mixed-use commercial development with 2 principal uses, commercial, restaurant, and residential with the 6 residential units. Section 315-504B, we're also seeking a variance. It details several permitted uses in the DC zone, but does not permit residential use or mixed-use residential and commercial use. We're seeking a variance for mixed-use development, commercial, and residential. Then table 5.04, among other things, details the non-mixed uses permitted in the DC zone. We're seeking a variance to permit a restaurant and 6 residential units at 331. Also, section 315-9.02A prohibits the increase of non-conforming structures. We're seeking a variance because we're proposing an addition to the pre-existing non-conforming building. Section 315-903A prohibits enlargement or extension of non-conforming uses. We're seeking a variance as we're proposing an increase of the 1 pre-existing non-conforming residential use on 331 to 6 residential units. And finally, section 315-9.04A prohibits the enlargement or alteration of non-conforming buildings and structures. Seeking a variance because we're proposing for 331 an increase to the pre-existing non-conforming building. So to give you some description about the site and history, I know that you're probably aware of it pretty well here in town, but I'll just give you our take on it. So 331 River Road was originally developed in 1920. The property is 0.61 acres large. It's located on the corner where Tolland Turnpike, Route 74, intersects with River Road, which is Route 32. It's located at the gateway to West Willington. In 1974, the property was being used as a gun shop. In 1975, a CO was issued for an apartment above the gun shop, and we have an exhibit that we'll provide. Therefore, functionally, the property became mixed-use commercial and residential, apartment, gun shop. Our client purchased the property on February 14th, 2023. When he saw the property, it was in awful shape and it was under foreclosure. Shortly after he purchased the property, there were numerous break-ins by 3 individuals, and I know we alluded to some of this earlier, but I'll just reiterate briefly. There were numerous break-ins by 3 individuals. 2 were repeat customers. They were just released from jail and known by the state police Troop C as lifelong criminals. Afraid of potentially stolen goods being stored there and illicit drugs, my client called up Troop C, the state troopers, and walked into the garage storage area with the state troopers. The garage storage area was filled with dozens of stolen lawnmowers, small machines, dozens of racks taken from the garden supply place next door, and 4 or 5 large containers with to be stolen Dollar General merchandise with the stickers still on them. When he went into the room with the troopers to within the garage, there were leopard curtains. This is going to sound great. A queen-size mattress, paint cans, box of condoms, a list of pricing for massages, and sex toys. I hope this is a PG 13 rated show. Inside all the cabinets, there are crack pipes. As for structural damage, 20% of the first floor is bowed significantly. And my client, as you alluded to earlier, believes it might be due to the heavy machinery from the print shop. What my client did was to support the floor, as been alluded to, with a frame underneath it to prevent the floor from collapsing. The town reviewed it and was happy that the client did it because it kept it from collapsing and creating a safety hazard. Additionally, the copper pipe was cut out of the place to be sold. Walls and windows were broken, and suitcases were stuffed in walls. This was an atrocious place before my client took this over. It was a threat to public health and safety, being used for illicit activities. My client has tried to clean it up, as I mentioned. Equally as concerning, squatters were using the bathroom inside and letting it overflow. When the water was turned on, there was a major flood. My client paid about $240,000 for the property, put in about $20,000 plus in cleanup, including the dumpster to take stuff out. He then spent about $75,000 to install a reinforced concrete pipe with a width of 22 inches to correct the major drainage issue with the underground water system that I'm going to have Christian give you a brief overview. Well, thank you.
At one point, there was a call from, I believe it was the local fire marshal or whomever from the fire department, asking if I was on the property. This was roughly turnaround in just end of December of 2 years ago. It was extreme freezing, and they thought that my well had a line in my well had burst, and they thought that there was water overflowing from a 1-inch pipe. And so after they broke into the property, turned off the well, to find that the well was never erupted because we had replaced for the lost copper all X lines to stop the flow of water and floods we got. After breaking in and securing the property after they left, they realized that it was an underground waterway as a secondary overflow for the pond that's on the Kids Kingdom side going up the hill towards Hilltop Restaurant. So that pond was engineered somewhere around the 60s to have two reliefs. One relief was further up the road and through a engineered system for the DOT, and then the secondary relief for overflow flowed through a naturally occurring brook where they positioned it to on the Dollar General side of the property. And then the head wall that took that flow, which is also on the Dollar General side of the property, came through my driveway, through the driveway and out to the far end of the lower elevation towards the Dollar General side. That had erupted, and there was thousands of gallons of water flowing over into the interstate. I was called by both the DOT and Monique Burns, engineering drainage specialist, and also a gentleman from the fire department. Showed up around midnight, left work, got there around midnight to see and give them permission to do an emergency excavation to repair the flow, stop it from icing into the interstate. So we did that. Further down the line, I never knew this existed. There was never any easement. There was never any documentation of where this pipe was, other than the clear head wall off my property. And there was no grate system on that and was never maintained. But after almost 6 to 8 months of going through the motions of getting the demands by the DOT, the commissioner getting involved and realizing that I couldn't repair something that would happen again due to the head wall not being on my property. The DOT discovered after they snaked it that there was road debris that was coming off the road and getting into that brook and basically backed up. And after the big snow melt, it exploded underground. And whomever in the 60s had a handshake agreement to encase and enclose and engineer this system, I was the one responsible now to have to repair it. And so after we got extensive data given to us from the DOT officials, we got permits issued, we got a local permit issued, we bonded the project. $75,000 later, all RCP, we didn't go with any plastic, HDPE. We did it right, we oversized it, and it was in conjunction with all the engineering specialists from the DOT and the DOT's head official inspectors. It was approved. They wanted additional work done that we had on the plan that has yet to be finished because of the weather. They want some additional curbing to be done. They want new asphalt curbing going up. It's work that we have to wait for. But, you know, we spent a lot of money going into this and repairing it.
That's it. Thank you. Hang out for a minute. So, at this point, we would like to discuss the kind of development plan and the site plans for the projects just for 331. You have the site plan for 331. We have for you tonight a kind of a bigger blow up of the plan. It's got a little bit more detail in it. So with the chairman's permission, we'd like to hand that out.
Please do, yeah.
Just for 331. Oh, actually, that's all right. We'll just
Welcome. Sure. Like, copy that you want.
This also was entered in.
This is exhibit 1 of the 331 variance.
Thank you.
Okay, so I think it would make sense at this point to have Mr. Vega kind of walk you through what the plan is for 331, if that's all right with the chairman.
Thanks, Tim.
Yes. We'd like to maintain the historic structure that's nearly 100 years old. We want to have the first floor, which is the higher elevation, as a 6-unit apartment. There's going to be 5 units on the first floor and 1 unit on the existing second floor. This is all interior work, a retro fit out that would include residential for these 6 units. There are 2 annexes on the building. One annex is the middle building, and the other annex is an A-frame off to the side. And so we've discovered that could be some damage to the foundation on the middle annex. So there'll have to be some additional support in this potential renovation. But what we would like to do is, with complying with fire separation requirements, have those 2 annexes act as the commercial use and put a restaurant there. We've got a long life partner of sorts who we've renovated and designed 7 restaurants in New York for, that would like to do a Brazilian churrascaria in that property, and will be dine-in restaurant. With that being said, we would also need to add a second floor, and that middle annex, which you're going to see addition at 463 square feet roughly, you're going to see that we would want to bump it out, the middle annex, to be the same width as the A-frame annex, so that we have more floor space on the first floor and the second floor.
At this time, did the commissioners have any questions about the plans for 331? Or you could reserve it till later, that's fine too.
Good. Okay, so this is a little over a half an acre, correct?
Right.
Is there septic capacity on this site for this many residential units?
We are looking to increase our land use by means of an easement. And they're currently working with that with the abuter. The abuter has been very receptive. Their attorney has been working with us for several months. They're waiting our final etude and civils to be presented. But they are very happy that we're not suing the hell out of them, and want to work with us on this being neighborly and allowing more people potentially to go shop at our abuter's store.
I'm sorry, I'm confused. Why would you be suing them?
The instance with the waterway breakage was due to their not upkeeping that head wall, which has cost me $75,000 in repairs. So they understand that we're very friendly, and they understand that we've been reaching out. They've assigned a special attorney to work with me on presenting this. And they also have never maintained that side of the property, which they're happy that this will work with the DOT, who is also in agreement that that needs to be maintained.
So
to avoid this.
you're saying the Dollar General is responsible for the culvert.
Correct.
Devastating.
It is their property, yes.
And presently the septic system is,
Septic system, we believe that there is only 1,000-gallon septic tank, and we also believe from a report found somewhere around the 70s that it was a single compartment.
So I drove past there today and it seemed like there was 3 or 4 giant concrete septic tanks in the back of the building.
Yeah.
What's up with that?
Those are put there for this potential purpose. We've got 2 dual compartment, 2,000 dual compartment tanks there, 2 of them. We've got a water cistern that will potentially feed the requirement for fire suppression. And then we also have a grease trap for the potential of the restaurant use.
There's also, it looked like a crane.
Yes, that was my,
For moving those around.
that was also meant for unloading the RCP pipe, 171 feet, linear feet of RCP pipe. They're 10-foot long, thousands and thousands of pounds.
These look preliminary. I don't see any engineer stamps or anything.
No, they're not. The submission is preliminary. We'd like to understand, in theory, if you guys come to the agreement that we can get these variances, we will take the next steps to finalize all the plans professionally with engineers and architect stamps.
Yeah, and that's a good point Mr. Vega makes, is that I was gonna get to this in the conclusion, but I might as well mention it now. The granting of the variance you can make conditional upon all the necessary municipal department approvals, such as building, such as health. So, by granting the variance tonight, you're just basically saying you can do this in this zone, but then we have to go for the necessary approvals and permitting.
How much land does Dollar General have that they're willing to,
They own that whole triangle. That whole end-to-end side is all Dollar General.
but how much?
How much are they willing to?
How many
provide
acres?
for these?
I don't know
Based
how-
on the requirement. If our engineer that we did hire is gonna come back to us after he finishes his A2 and say, this is how much you will need to be compliant with the health code and, what you need for your drainage, right? So that is solely on the, now, Dollar General, their attorney came back to us and she said, well, we'd like for you to, if you're gonna be responsible for this easement of the waterway, we want you to take that whole side from where the discharge across the pond comes and provide, whether you develop all of that side for use or not, we want, if you're putting your hands on it, we want you to own the whole run for the waterway. Which also helps to, we'd have to go to wetlands and, DOT's already on board with it, but it really is, if needed and how much needed, that's how much they're willing to partake with as part of this plan.
I heard you say you're working with an engineer.
Correct.
Are you an engineer yourself?
I am an engineer. I educated as an engineer. I don't have reciprocity in Connecticut. I am working towards it.
Do you have a professional engineer license or?
In New Jersey and Pennsylvania. Yeah, I also used to teach engineering and electrical engineering, mechanical engineering, ASC certified, all of that jazz. I got my certifications in the service. I was a CN, which is equivalent to an E3 in the Navy.
How many years experience as a PE do you have?
I'm sorry?
How many
Over a
years
decade.
experience?
Over
Over
a
a decade as
yeah.
a PE. It looks pretty ambitious to me, to get all this into that small little lot. You have a visual plan on all this? Do you have a path to profitability? You suppose you'd be profitable sometime 3 years, 5 years, 10 years? What do you think?
Right. So we were able to pick up both properties. We'll address this one first at a very reasonable rate. It was prior to Yukon expanding, even, they thought about 60 acres in Willington. It was prior to the Georgia development firm picking up that property that's 4 miles down and building that 20 building complex. So again, it was relatively COVID time. And we were able to take these considerations that I never really wanted 331. It presented itself to me. But those considerations and the price that we did purchase it for, once we do develop it within the 6-month mark of just the residencies, we would be at 30%. So every curve at 30%. So by the 18-month mark, we'd be profitable. And for the residences zone. partnership that we're looking for the restaurant part, would be more of a long-term investment. A lot more money that goes into a restaurant. And, you know, typically there's like a 5 to 7 year mark before you actually start making money. Yeah.
Right. Yeah, that's to be expected.
Plan shows 5 apartments,
One on the second floor.
huh,
One on the second floor.
on the
It's
second
the
floor.
existing footprint of the second floor.
On 331, ownership of the lot is in the name of 331 River Road LLC.
Right.
If we look at the corporate paperwork on that, you listed your residence address on that as 331 River Road, Willington, Connecticut.
Correct.
But you don't live at that address.
No.
Then how do you list that as your residence?
In the midst of moving, I basically registered myself there because I still had a New York license. I never even moved it over when I moved to Shelton.
Yeah.
So I wanted a Connecticut license, and you know, there is an active certificate of occupancy on that property. So I was able to get the DMV to give me that location as a residence. I currently live in Stafford Springs.
You're counting on the CO that was issued back in the 70s.
That was never removed. Correct.
To that point, if I may, I have a copy of that certificate of occupancy, that with the chairman's permission, I'd like to hand out if that's.
Please
okay.
do.
Along with that, I have a list of the single-family residents that are located in the DC zone, so for your reference. Review.
The CO is exhibit 2, the property lease is exhibit 3.
Thank you.
Are there any other questions about the plans particularly? I could move on if you like me to, or if you need a moment to think of other questions, or you want to circle back, whatever the commission's pleasure.
Chair, recommend if the public has anything to comment on this particular property, hear from them, and then you could, you know, close and move on to the next hearing.
Well, I'm sorry, I did want to touch on the legal standards for variances before we close, if that's all right.
Fair enough. I thought you were suggesting you were going to move on to the other property.
Yeah, I was going to move on to the next part of this presentation.
Sorry.
That'll wrap up.
Yeah, I don't know if you want to open it up for questions, or do you want to move forward with what you want to say? Or?
Yeah, I would just like to finish the presentation and then certainly, you know, welcome public comment. Figured this way we'll get it all out on record. All right, so, so as to the legal standards for variances, as the board knows, you're authorized to grant variances under your regulation section 315-21.01 and also Connecticut General Statute section 8.6 in cases where the imposition of the regulations results in exceptional difficulty or unusual hardship. In deciding whether or not to grant the variance, zoning boards of appeals must address the 3 following questions. Number 1, is there undue hardship? Number 2, would the granting of the variance be out of harmony with the general intent of your regulations and your plan of conservation and development, also called the POCD? And would it conflict with the character of the neighborhood? And 3, would the granting of the variance result in adverse impact on the neighborhood? Now, as to 331 River Road, hardship originates in the strict application of your existing zoning regulations. In fact, your newest zoning regulations found in Table 8.02 clearly intend to reserve DC zone property to be established on large parcels of land, specifically land containing 5 or more acres, and preclude mixed-use commercial and residential use. Please remember that 331 River Road has had a residential use since at least 1975, as shown on that CO, and contains less than an acre, and it's an odd triangular shaped property. So 331 cannot be developed in accordance with your current DC zoning regulations. As to harmony with the regulations, the POCD in the neighborhood. The second standard for granting a variance is that the variance must be in harmony with the spirit and intent of your regulation, your POCD, and the neighborhood in question. Regulations now recognize that accessory residential use is now permitted in the DC zone, and that the purpose of the DC zone is to support high-quality commercial development that serves the needs of the town and promotes compatible mixed uses. Or as I'm referring to section 315-5.04. Obviously, our proposal mixes commercial and residential uses, and is within the spirit and intent of section 315-504 of your regulations. Most critically, I direct your attention to your master planning tool, the Willington POCD, which is dated from 2018 to 2028. If okay with the chairman, I have a copy of some excerpts, so you don't have to look at your big binder, and I can hand that out to the chair.
Please do.
Thank you. Appreciate it. Taking down, yes. Does everybody have one?
Got a spare, I'll take it.
There you go. Thank you. Okay, so now that you all have the excerpts from your plan of conservation and development, one of Willington's development-related strategies in the POCD is to enhance and foster village-type development in West Willington. That comes from page 49 of the POCD. The plan recognizes that Willington will not attract major retail development. Instead, as page 56 of your POCD notes, Willington may be a stronger and more defensible location for smaller niche businesses and services that serve primarily Willington residents. That's exactly what we're proposing here. Our proposed developments have many village-type elements, including it's located near the intersection of Route 72 and 32. Proposed mixed uses create an active village-type environment. Both the restaurant and the ice cream parlor, which we'll get to, will create a focal point at the gateway to West Willington. I also make reference to page 54 of your POCD, which contains the development goal of creating village-type developments, mixed-use buildings, and/or mixed-use developments. One of the major goals of creating village-type developments is to encourage mixed uses, which is exactly what we're doing here. Our proposed developments fit perfectly with the POCD's suggested economic drivers that are consistent with village-type characteristics. As to harmony with the neighborhood, in addition to the historic residential use of the property, there's at least 9 single-family homes located in the DC zone. And that's part of that handout I just gave you before. Final standard for granting a variance is whether by granting this variance, you will be adversely impacting the neighborhood. It doesn't take a rocket scientist to conclude that taking 2 derelict, functionally obsolete, non-performing properties and turning them into something positive and productive at the gateway of West Willington on 2 principal state roads, routes 32 and 74, turning them into mixed uses that are aesthetically pleasing, and village-type developments that will produce appropriate economic development that can only positively impact the neighborhood. We're not talking about dropping a Walmart here or some franchise chain or something that's going to change the character of the town. We're putting something there that is going to complement what's already downtown and will be used by Willington residents, give them another option for restaurants that provide much needed housing, which is in harmony with the rest of the neighborhood. So that's all I have to say about 331 at this time. So I'll send it back to you guys and go from there.
Can I offer some comments from the staff perspective before you go to the public? Sure. I have a staff report, which is in your packets. So it's funny, I'm sitting here trying to defend this suggestion that on behalf of the town, we've been very anti-development. And a couple of years ago, I was sitting with the Planning and Zoning Commission being accused of being too development friendly and pushing Willington to be something that it isn't. So it's funny how things shift, and I'll laugh about that at some point, maybe. So I think, and obviously we'll defer to Ken and maybe ask him to go through this correctly, but it's probably good to do a level set on what is actually being requested here. As far as my research and Peggy as well, I don't know that you guys have had a use variance request. This is different than this traditional variance request. This is not sort of your standard, setback requests and types of things that you normally see. I mean, I think had 5 meetings in 5 years, but there's a different threshold, and there's a reason why they don't happen that often. So as I have explained to the applicant, to the attorneys that are here, to the attorney that's online, the intent of development of the property is something that from a staff perspective, I have no issues with. It's great. Development is great. Willington is not in a position where it can be picky, right? We don't get to sit back and say, well, bring us this instead of that, right? We want to work with the people that are here that want to invest. All fine and good. From my perspective, this is not the way to do that. The meeting that they had suggested they went to with planning and zoning was intended to be an informal discussion with the commission on use of these buildings. They had submitted a text amendment application to amend the DC zone to facilitate use of the structures the way that they want. That was my recommendation. They submitted an amendment. After reviewing it, we had a meeting with Mr. Willinger, who's online, Terry Willinger, and the property owner, and we reviewed it. And it was, for many reasons, not something that the commission really could take action. So the recommendation that I made was withdraw that application so that you can have an informal discussion with the Planning and Zoning Commission about what the heck you want to do, get their feedback, and then you'll have that guidance so you're not sort of blowing in the wind. Put it on the agenda. It turned into a discussion where the property owner was talking about the CO that he referenced and that he feels it's a lawfully established CO, or he has the right to continue to use it as he has indicated. And I presented our position, which that it is not a lawfully established standalone CO. It was for a caretaker's unit associated with previous uses in the building. The commission agreed and the conversation ended. So not only is the idea that there's some lawfully established freestanding CO not correct, and he submitted an FOI request. We reviewed every regulation that's ever been in effect in the DC zone since the town adopted zoning. There has never been residential uses allowed. But we intended to make progress at this informal meeting, and that was not ever part of the discussion. I've included in my staff report what they've requested, and I've also included the permitted and special permit uses for the zone. It's on pages 1 and 2. I then get into some case law that I think is important for what you're considering. The applicant has to show really that from a hardship standpoint, there is no use of the property. There are 24 uses that are allowed, and there's many uses which have been conducted historically. This has nothing to do with the appeal that's pending. This has nothing to do with a whole lot of other things that I will not get into, but maybe another day. This is an end run around the zoning regulations. And from a planning perspective, we don't simply submit a request for many variances, including, to use a property, when we don't even have the information to demonstrate what variances, whether or not they're prudent to provide. They're calling it a non-conforming building, but we don't have a survey that shows whether or not it's non-conforming and to what extent. You don't just get a blank check to enlarge a non-conforming building. You say, hey, I want to expand to the west. I want to expand up. I need a variance. So this idea that we get a variance to a half dozen sections of the regulations to then allow for carte blanche development, whether that be parking issues, whatever, is a huge sort of misapplication of the zoning regulations that we hold everybody else to. So from a planning perspective, I support where they're trying to go. I do not support their sort of interest in going in this direction. We have been asking for a survey prepared by its engineer and information about building plans and approval from the health department to get a sense of what is allowed there so that we can start to get our hands around what nonconformities might exist. Buildings already in the DC zone. So the idea that that creates an issue with development doesn't make sense. They're not changing this. So really it's, I need 20 spaces, but I can only put in 5, right? These are the things we're talking about. But we don't have a survey. I've asked for months. So I want to make very clear for the record and everybody hearing what may be said or has been said. The town, whoever we are, like there's some big department, even though it really isn't, supports use of this building. We have mixed use in other zones, but not in a way that takes the special permit process and all of the checks and balances that exist in the zoning regulations off the table. So I think the idea that this is a use variance request is important for the commission to keep in mind. It's a different standard and it is a completely different process. It does not, they don't just continue on their merry way through all the normal steps after this, right? This is sort of skipping that traditional P&Z process. And so I have concerns about what that sort of does. Not about the ultimate use. So unless there's anything in there specifically, and I will leave it to Ken to interject and tell you whether or not I'm really off base with what a use variance is. Let me just check my notes really quick. So they've talked about you need to decide if it's out of harmony with the regulation, with the comprehensive plan. Residential uses have literally never been allowed in the DC zone, right? So I think that is something that, again, depending on the level here and not having any of the technical background from a surveyor, an architect, a sanitarian, to even know if these uses are supported, to give them that approval up front, I have some concerns about just from, again, a process standpoint. I think the fact that they've already suggested they have a tenant line, again, supports that there are fundamental uses for the building. This is not some confiscation where there's no use that can be conducted here, and they need to get this use variance because the 25 uses that the zoning regulations allow are not possible. We allow a whole bunch of stuff. So I struggle to sort of understand that.
Mike, a quick question.
Yep.
We do have this sheet here that shows 9 single-family residences in the DC zone that they grandfathered in from prior before zoning.
So without having looked at that list, I would bet a whole lot that every single one of them was constructed prior to the town's adoption of zoning. You haven't had zoning for many years, so they would be pre-existing non-conforming.
And people also like clue me into the caretaker CO that was granted. Was that
So there was a
gun shop time?
So yes, if you look, it says apartment above gun shop. That's what's in there. And if you go through the special permit that was issued when that use was approved by the commission, there's clear documentation in the minutes and the condition. I think the chairman at the time is sitting in the room, that it was intended to be occupied by a caretaker, that it was not an apartment. It was sort of an accessory use to, and so they didn't consider it a residential use because it's not allowed. So my guidance to the property owner has been that use exists and can support a lawfully established principal use on the property. But again, we don't have that. So you may get to a point where that apartment can be occupied in support of a principal use, but that's not where we are now. And again, that, me out of it, even though it wasn't the intent, he brought that information to the Planning and Zoning Commission during that informal discussion. The recording is online. You know, I referenced it in my thing. And they agreed that it was not meant to be a standalone apartment. So lawfully established or lawfully issued or all those things. Yes, it was issued at the time, but not for a freestanding, independent, occupy at will unit. And a lot of that has to go with the existing septic that's on the property. There's some documentation from Lynette. So I again, having been in this town for several years now and hearing from the public and the whole process that we have, I have some concerns about the long-term implications of really how the town gets its hands around making sure that this works in conjunction with the zoning regulations if we issue them variances for the several regulations that they've requested.
I understand, thank you.
Before we go to the public, I have a question for Mr. Vega. Tax records in town town of Willington. Says that 331 River Road is owned by 331 River Road LLC. But the address given for 331 River Road LLC isn't 331 River Road. It was 665 River Road, Unit 10 in Shelton.
Right.
And so, you know, on your corporate paperwork, it says 331 River Road. But on our tax records, it says 665 River Road, Shelton. Why the discrepancy there?
If I may address, there's a difference between tax records, what's on the land records, and what's with the Secretary of State. They don't necessarily have to be in order, they're not consistent. So, and again, I don't see how that's relevant to the discussion here tonight about use variances.
It's just troubling to me that there was quite a chain of LLCs in ownership going on here.
That's standard. Standard.
Okay. Is it standard for LLCs to be dissolved and then be reinstated?
Yes.
While they own property?
Absolutely, because oftentimes someone will forget to file an annual report, then the Secretary of State on their own motion will dissolve the corporation and it gets reinstated. That's not a common law.
It
And
doesn't
again, not
jeopardize,
really
doesn't
relevant.
jeopardize the ownership of the property, so that the ownership entity doesn't exist.
The entity does exist. We have
But
records
it's
from the
dissolved,
Secretary of
it's
State.
dissolved,
Doesn't
it
matter.
doesn't exist.
Doesn't matter. You have a deed on the land record showing who the owner is. Until that is changed on the land records, the owner is who the land record says, town clerk. Also, with the LLC, it can be reinstated, and that does not have any effect or impact on the ownership of the property.
And what's Mr. Vega's association with that LLC? Because I don't think that's reflected in the land and on the Secretary of State's. It's just a matter of standing, just to make sure just the record's tied up.
Yes.
And that it's gotta be reinstated and what was taught, what is.
It has been reinstated. In fact, I can provide counsel with the Secretary of State record.
This, Mr. Chairman, I'll pass that to you, but this suggests that it was reinstated this year, and then Mr. Vega is listed as a managing member of the entity. Tied to Vega. And then you've given, can we I hold down the one for Foundry as well? I assume that.
Yes,
off of
that's
that
fine.
to the next
Yes.
hearing. So, Mr. Chair, for the next hearing, there looks like there's a reinstatement for the Foundry as well.
Even though it came up in discussion, do we want to enter this into the record? Okay, is there any?
Mr. Chairman, I'm sorry. There were some comments made by Mr. D'Amato. I don't know when you believe the appropriate time. I could do it in my rebuttal at public comment or whenever the chairman believes it's appropriate.
How about if we can handle that in your rebuttal. I'd like to let discussion go to the crowd and then we'll wrap it up. Mr. Tulis.
That's Trump Lewis Hills Road. One thing I would like to hear tonight from the board's attorney is the difference between a variance and special exception as outlined in our zoning regulations. Because they are two separate and distinct items from what I understand. A variance allows for adjustment dimensional requirements because of physical constraints. We do that all the time. You want to add on 10 feet and your 50-foot side yard now has to drop to 40 feet. So you get a variance. That's cool. That happens all the time. But as I understand it, special exception may allow for a use not otherwise specifically allowed by our zoning regulations. Am I correct in my understanding? Because what's really being asked for here are a few variances and a lot of special exceptions. Great. Okay. I'm not opposed to this, to 331 being developed. I'm a little concerned about its track record because I see it's changed hands, but 5 times. Originally by B&M Realty Trust in 2005, then CSB, then David Miller, then David Stewart, and now 331 LLC. What are those connections with Mr. Vega? Are there any connections? Or did Mr. Vega first acquire this property in 2023? Doesn't sound like it. Sure would like to know. Anyway, I look at the site plan for this. And the title block is labeled self-certified conceptual drawing. Well, that's certainly not a licensed professional engineer. There's no boundary survey for this property. And it appears from the site plan, and if you look at the historical site plans for that property, that a portion of that overlaps with the Dollar General's project. I got hard to determine what the site plan has been provided. Anyway, you get more specific. More than one principal use on a single lot. Okay, I think that can be done under a special exception, not under a variance. There's an issue with 315-5.04B. I'm not sure what that is. Table 5.04 clearly shows multifamily housing is not allowed in the DC zone. Again, we want to adjust allowed uses. That's not a variance. That's a special exception under our regulations. Now, I also look at the plans, and it appears that we're adding a second floor to the entire footprint of this building. The addition to the south and the original main building. Am I correct in that? Because we're talking about a second story resting. Are we going to put apartments in the bottom floor with no windows on the south side, the east side, and maybe a few tiny windows on the north side? Okay, that we're not going up on that end of the building, the original. The major portion of what was a gun shop was on that plan. Let's see, what else? So I may not be correct in what I stated in my letter. As far as second floor going over the entire footprint. Adding on to this building, whether we bump it up a floor or we add that little piece of an addition on the west side, that's an increase in non-conformity. 315-9.04B may allow for enlargement, but it cannot be made compliant with the requirements of Article 8, the zoning regulations. The site plan and any associated documentation that I've seen so far, there's no stormwater management addressed by Connecticut licensed professional engineers. There is no septic system layout and basis for design provided, nor has documentation of approval by Eastern Highlands Health provided. We're going to grant a special exception or variance without that information. I don't think that's warranted. Interior modifications. We've heard a little bit about that, so what I stated in my letter may be justifiable from the applicant's perspective. But this is a 105-year-old building. He wants to add a second floor to it. Might it be better served? He can do this. The non-conforming building, demolish and rebuild the same footprint. That's certainly possible. Anyway, any modification, structural modifications made to that building inside had best be reviewed by a structural engineer licensed in the state of Connecticut before any finishes are applied. Because if you can't see what the structure is, you can't evaluate it. So I'm urging this board to discern the difference between a simple variance versus special exception requirements. Special exception falls in the same category as a special permit. And that's the end run that Mike was talking about from my perspective. I did 15 years on planning and zoning, many of those years as chairman. A lot of these things came across when I was on the commission. I just think there's too much missing information for you guys to act on this carte blanche. I think that the application is submitted should be denied without prejudice, and let them come back with a cohesive, clear-cut direction they want to go, where the variances need to be, where the special exceptions need to be, and whether or not a special permit is imposed. I'm going to share this letter with you.
Thank you.
First page, the first bullet, I say special permit. This should be special exception.
This is exhibit 6.
You all set?
Hey, Rob. Hello.
Ralph?
Ralph.
Yo.
Someone on the TV.
Oh, sure.
Go ahead.
Okay. If I can, I'm getting a lot of feedback all night, so it's hard for me to hear everything, but can you hear me as I'm talking now?
Yes.
Yes, can you identify yourself, please?
Yeah, I was just going to do that. My name is Charles Willinger. I'm a partner of the firm of Willinger Busey, representing the applicant. I'm just recovering from the flu, so I wasn't going to infect anyone by coming in person tonight. But I do want to make a couple of comments. First, I'd like to remind, because I think we're getting lost in the weeds. There's too much misinformation, special exceptions. For example, that gentleman that was on the board for 15 years, he should frankly know better. A special exception, you can't invent uses. It's got to be a permitted use. So the only way for us to go forward with developing that property is to have this initial, what we call a concept review by this board, because we're not going to be spending another $50,000 or $60,000 on surveys, on engineered plans, on design septic systems, and not know from your board that we could have a mixed-use development. So I want to make it clear about one thing before I get specific. Just in general, by Connecticut law, every town that has a planning and zoning commission must have your commission, a zoning board of appeals. And there's a reason for that. P&Z has to follow your regulations. And in a zoning regulation, what the regulation says, it says. And often in the real world, as we all know, particularly with these properties, nothing fits nicely in accordance with the rules and regulations in your zoning regulations.
So your commission has frequently been referred to by the courts as a board of practicality and flexibility. And what I'm saying about this particularly holds for these two properties. We're asking you to be practical. These two properties, my clients have spent, you heard what he said, $75,000 just on the piping, plus cleaning the place. They were two despicable properties. He described that in the tens of thousands of dollars that he's invested. Now to have him spend another $50,000 or $60,000 on plans, and we get to you and you say, well, we don't want mixed use, that's another $60,000 on down the drain. What you should, in my opinion, with all due respect, what you should be asking yourself is, are we going to wait another 10 years? Because if we do what Mike D'Amato says to do, it's going to be another 10 years before this property ever gets developed. These are the gateway properties, as Rob said, to your West Willington town. And we want to fix them up, and you want us to fix them up. I heard what the first selectman said. So let's see if we could all be practical and get something done. What we're asking you to do is simple tonight. We're not asking you to approve the septic. We're not asking you to approve any engineered plans. All we're asking you to do tonight is to grant a variance, a use variance, which would allow some sort of housing. It may not be 6 units, because I'll tell you why in a minute. It may only be 1 unit, maybe 2 units. We don't know at this point. But we do know we want mixed use and an ice cream parlor on one site, mixed use and a restaurant on the other site. And we want to develop the property. And you want us to develop the property. Anybody with half a brain would say, yeah, develop the property. So what we're asking you to do tonight is to approve these variances. Now, Mike is 100% wrong when he said, oh, we could have some use on this property, so it doesn't qualify as a hardship. That's nonsense. This is not a confiscation argument. It meets the hardship tests. We're improving the property. There's not going to be any adverse impact on the neighborhood. It's got to be a positive impact, because we're taking these two rotten, despicable pieces of property and converting them into some sort of mixed use where they're going to be paying taxes, they're going to be looking good, and they're going to be inviting. The bottom line is, a hardship is that these are not designed commercial zone properties, because under your new regs, you got to be a minimum of 5 acres, and you're looking for bigger commercial use. And under your regs, you could have residential use, but it's got to be accessory. I don't know how that works. I don't want to get too technical because there's too much technicality. How you get accessory use of residential when the principal use is commercial. But that aside, that's why you need a use variance. What we're asking you to do is simple. Say to us, yes, we approve a use variance without any number, a use variance allowing a restaurant on one, ice cream parlor on another, and residential on both. Subject to, and condition your approval specifically, subject to us coming back before you to get what they call the development variances, which means we'll spend the $50,000 or $60,000. We'll come back with a really detailed plan with an A2 survey. And I explained this to Mike not many times, about 5. And we'll come back to you and we'll get, and then you have the second shot of saying no, because we're going to ask you for variances of lot size, variances of setback, road frontage, parking. All those development issues will be addressed at that time. So you'll have to, and there'll be no development without you approving the second series of variances. We'll also have, as I said, engineered plans. We'll go to the engineering department. We'll sit down with Mike and get his more specific comments on our plans at that time. And it'll be subject to all other land use approvals. For example, if Michael is under the impression that after we get your approvals, we still have to get a special exception before PNC, well, then we'll go. But at least we've got the first start on a long road of getting these properties back in play for your town, back on the tax rolls, and it's something that you honestly should promote. We're not asking; it's not a stretch. We're asking you to just allow this mixed use on 2 pieces of property that can't possibly fit into your regulations as designed commercial properties. And it's really that simple. I don't want you to get lost in the weeds. Give us an indication that, yes, you'll work with us knowing you got the second bite of the apple, as does the health department, as does the septic department. So make it your approvals subject to septic department, health department, engineering department, Mike's review, and all the other development variances that we need. That's what I have to say. Thank you very much. I do hope, because an affirmative vote is going to be a real plus for the town, and it will save my client the agony of putting another $60,000 on this property and telling only to get a denial. Thank you.
Mr. Willinger brought up taxes a couple of times. It was asked earlier if your taxes are current on these buildings, and it was getting out of bounds, I guess, on our discussion tonight. But with Mr. Willinger bringing it up, I wonder if we could know whether or not the taxes are current.
Well, what Attorney Willinger brought up was that this will create taxes in terms of the people who are going to live there, in terms of the restaurant, in terms of permit fees. I don't. It's easy enough to check the tax collector website and find out. I don't have that information handy on my phone, but
do you have an idea?
Right.
Yeah, I know that we were in the arrears. I know that we've been working with the town assessor on putting that forward. We got a couple checks last year. Unintentionally, as I said earlier, we have not been putting a lot of attention into this because we had no pursuing that use. We're going to catch up probably in the next couple of weeks to be fully caught up.
Well, I'm all in favor of bringing new business to town. I really am. Okay. Bringing new business to town lightens the load on the residents who shoulder most of the cost of running the town, because most of our property is residential. But I'm very concerned that if we bring businesses in that don't thrive and don't actually make that contribution to our taxes, then what have we done? I think we have a responsibility to the taxpayers to make sure that, and that's why I was asking questions earlier about your business plan, about your path to profitability. I think that it's important that any business that comes in here has the ability to thrive. And I'm concerned you're behind on your taxes. So it would be good to see those get paid.
Yeah. Thank you.
John Patton, Allen Turnpike, as Willington. I've been accused of having half a brain.
Not by me.
All right, but I like to think that I have a full brain, and I don't think this plan is a good one. The problem you have as a ZBA is the fact that they need a hardship, and apparently the hardship is spending $75,000. Money is not a hardship. So you as a ZBA can't approve a use variance because he has to spend money. It just doesn't work that way. And also, as I look at this as mixed use development, both whether you're the ice cream parlor or this one, what I'm seeing is flop houses disguised as a mixed use. Because you get 6 apartments, 5 apartments, and 5 apartments over here. The businesses go away, what you have is apartment buildings. And that's really what's being asked to be approved here. Because if the businesses don't thrive, and the businesses go away, those apartments are still there. And this is a design commercial zone. Those houses that are in there, I can tell you, I have personal knowledge, the fact that planning and zoning many years ago decided that they were gonna do planning, they had a fit of insanity. So we're gonna do some planning, and so they made all those houses commercial. You know, and the idea was that over time, the houses would give way to commercial. That was the planning of that. Not the other way around, because what's being asked tonight is to actually take the commercial and put it back to residential, which is the antithesis of what planning and zoning wanted to do, I don't know, 37, 40 years ago. I forgot how long it was. So the ZBA perspective, doing a use variance, a monetary hardship is not a hardship. You guys gotta vote no. I don't know how else you do it. Thank
That's
8319 versus 920 Connecticut. I think as a resident, we would hope that you would all also consider being good stewards of our land. And this is a 0.61 acre. And putting 6 apartments and a restaurant on 0.61 acres is just overusing that land. There's no reasonable way to get a septic for that much use. There's no reasonable way to do a well there with the water anything. And parking is gonna make it a nightmare to try to convert into this. So I'm gonna ask all of you to raise your supports to go down and consider that in your approval variances. I'm all about business. I think a business should go in. I don't think a business and 6 apartments should go in there. Make it a restaurant. Make it apartments, but don't do gold.
any questions?
Mike Johansson, Old South Road, the road. I'd like to remark to 331, anything printed was there for a long time. The only reason anything printed moved down the Phelps Plaza is because they were selling the building. Anything printed is still alive down in Phelps. So that 331 can be desirable to a business as it is currently. We don't have a lot of commercial buildings for rent, lease, sale in Willington. So the fact that that would lead to change to attract a business, I don't believe it's actually true, because there was a business there that's thriving. They moved locations because the owner wanted to sell. So why do we have to change them to make it a mixed use to present hardship when there was businesses already there? 335 was before my time. I'll fully admit it. Repco had it as their antiques place. Nobody's tried to put anything else there since, so we don't know if somebody's looking for even just a business to put there. So we're kind of assuming that nothing can thrive in those buildings. We're just kind of saying that we have to do this to get something to go there, which I don't believe is actually factual.
Thanks.
Ralph?
I want to make one additional comment. What I heard the gentleman online was that Willington requires 5 acres for a DC zone. Well, if you want to create a DC zone, yes, you need 5 acres or more. But a lot within a DC zone only has to be 40,000 square feet. So that statement was a little bit incorrect.
Thank you. Now, even if we were to entertain a motion on something like this, you got a whole list of things that we'd be throwing up carte blanche. I mean, I would want to go through each one of these and discuss what you're actually looking from us for your variance.
Keep in mind that there is a difference between what you guys do, which deals with variances of the zoning regulations that exist, versus what the building department does, what the health department does, what the engineering department does, etc. This project can't happen without all of that being approved. What we're asking of you is your specific role, which is to vary your existing zoning regulations which do not currently permit mixed use development. And I would refer you to the POCD that this town adopted. It said this is what 10 years, 2018 to 2028, where we want to go as a town. It talks about work with property owners in West Willington to explore development approaches, mixed use buildings and or mixed use development that will result in a village type development pattern. And you have a picture of West Willington on page 54 with Route 74, Route 32, with the Dunkin' Donuts, with Phelps Plaza. It's exactly the area that you talked about. We want to promote mixed use. Mixed use can't exist in that location unless the current zoning regulations are varied. The hardship is not the money he spent. We never said that. Attorney Willinger pointed out that there's been a lot of money invested. We're not claiming that as legal hardship. What we're claiming is you can't develop this property in accordance with the POCD without you varying the current zoning regulations. That's what we're asking for. That's the hardship. You can't do what the POCD says we want here. And we want in this area of town specifically.
Is that the only thing that the POCD says we want in that area of town?
No, it's not the only thing, but you're talking about the plan recommends that Willington maintain and enhance village type development patterns in South Willington, Willington Hill, and West Willington. It talks about the economy, vision state. It talks about wanting to have mixed use developments as part of this. It's in black and white in your POCD that you adopt. So either you mean it or you don't. So that's what Attorney Willinger is referring to. Give a message that, hey, POCD is something we believe in. We enacted it. It's where we want this town to go to have sensible development and economic benefits to the town. If that's what you really mean, these are exactly the properties to make it happen. It's specifically referenced.
The process could have been to go to the board, the Planning and Zoning Commission with a properly worded text amendment, and we would not be here today had you followed that path. Correct?
But there are different paths to get to where you want to go as a town. I think you're getting kind of lost in the process without understanding that this here is a valid legal process that is part of your sole function as a zoning board of appeals. You can't have a special permit or a special exception when it's not a permitted use in the zone. You can't, it just can't happen. It's not legal. It's not the way zoning regulations work. You have to get a variance in a situation where it's not a permitted use in the zone, which is the case here. So the idea that this is an end around is frankly offensive. It's part of what procedures exist is established by your regulations in state statute that allow an applicant to say, your regulations won't permit my proposed use here. I'm asking you to vary it. And I'm asking you to do it based upon your POCD, upon the hardship that the particular property represents. That's the procedure that is supposed to be used. That's the whole reason it exists. The whole reason, frankly, that a zoning board of appeals exists, among other things. So.
Well, rolling back though, I don't know what you're looking to vary on each one of these regulations. Okay. 315-422. Okay, design development zone, should be no more than one principal use. Assuming you're looking to vary that.
Yes, to have two uses.
To have multiple uses.
Yes.
The existing reg says that you specifically says you cannot have a residential as one of the two.
And that's what I was gonna get to. And it cannot be residential. So you'd want, I don't know if we can even vary that. I don't know if that's within our realm.
If there was, if there was evidence that the property could not be used absent that kind of a variance, there's no reasonable use to be put to the land, and they actually were able to prove that, then yes, you could. The only, your regulations prohibit use variances for a list of prohibited uses that are in the regs. And residential is not prohibited anywhere, everywhere in Willington. So you have a section of your regs that have a specific list of uses that are prohibited in Willington, and a reg that says that you can't give a use variance for them. So theoretically, one of the classic, cases was actually the reverse. It was residentially zoned property, and it was right next to a railroad track, and there was evidence. This was a case, Plum versus the zoning board of appeals in New Haven, and they presented a lot of evidence. They said there's no way we could put a residence here in this small parcel of land right next to a railroad track. It needs to be commercial. If we don't use this commercially, there's really nothing we can do with the land. And this Connecticut Supreme Court in that case said that there was ample evidence to show that the regulations that were authorized would not allow any reasonable use of the land. Question here is, has the applicant demonstrated in that long list of uses that are permitted in the zone that none of them could be viable on this property? And that's the crux, at least as to the use variance issue. And they say they can't. And it seems clear that there might be some need for some variances because the lot's undersized. So there maybe there's provisions of the regulations that would allow for development because it's a pre-existing lot, and that they might not even need that variance. But it seems the critical one they're looking for is the one to allow for the additional residential use. And have they demonstrated that they can't use the land if they don't have the ability to put residences there? That's the crux.
So that would be looking at one or the absence of the commercial use. Then you'd look at residents for the use of that lot if you did have the ability to use it as zone.
To be essentially, they have to show to put the residential use. From the testimony that we heard from someone, I was going to suggest maybe the public hearing needed to be kept open so that you could confirm whether or not the list of residential uses that were submitted to you were legally pre-existing, as opposed to being permitted. Mike had testified earlier that these regs never allowed residential use. This exception was this caretaker that was at the gun shop. So we heard some testimony that maybe satisfies the board that you don't need any more information, that in fact that list of residences that are allowed in the zone are not allowed because they were allowed by zoning, but were pre-existing residences in the zone. Because the whole concept of zoning regulations is to try to get rid of nonconformities. So over time, as was suggested, if those existing homes were there, but it became a commercial use, the idea is in the long run, they can continue to operate as a house, but ultimately it will all get converted to commercial. And then the existing regs adopted by the Planning and Zoning Commission say that you can have mixed use in this zone, but the mixed use can't be residential. And so in order to be able to get a variance, that use variance, they'd have to demonstrate that they can't put this property to a pure commercial use. And have they proven that? They've said they can't, but did they provide any evidence to support that? That's what your commission has to address ultimately. I don't know whether you need any more evidence or whether you need to close it. You got the other hearing too, that has to do with the ice cream parlor too. I don't know whether or not you want to go through each of the specific ones. Do you think that the commission could rule based on the evidence that's been submitted?
Well, I was just looking to see I mean, for me, there's so many things I really can't tell. Like table 5.04, pretty big table. What exactly do you want to deal with that?
So that table details certain non-mixed uses that are permitted in the zone. What we're asking for is to allow in the DC zone a mixed-use development comprising a commercial use, that being a restaurant, and residential units, that being the residential component. Because right now, that's not allowed in the PC zone. So really, at the end of the day, what it all comes back to is we want to do a mixed use here, commercial and residential, as outlined by your POCD. Right now, the zone and the regulations do not allow it. That's why we're asking for the variance.
Rob, let me see if I can help the chairman. And Mr. Chairman, it's really simple. On these sections, since you're looking at it, if you're inclined to approve it, the wording would be granting us a waiver. Let's go to the first one: a waiver or a variance of section 315-411, granting that variance to allow two principal uses on that property, one commercial and one residential. That's all we're asking for initially. Doesn't mean it's going to get built, because we got to go for that second series of approvals. The second one that you mentioned is section 315.504B. And again, you could say we approve the variance of that section to allow a mixed use commercial and residential on the property. It's the same wording on every one. 3, vary table 5.04 to allow a mixed use commercial, or you could say ice cream parlor on one, the restaurant on the other, or you could just say commercial and residential. The other one, the last few have to do with non-conforming structures. Section 315-902A, you would say you would grant the variance allowing us to put an addition on an pre-existing non-conforming building. And that addition is shown in the floor plans that you have before you. The next one, same thing, section 315-903A, you grant a variance allowing us to enlarge or extend a pre-existing non-conforming use on the property. And the last one, you would grant section 315-904A by allowing an addition to the pre-existing non-conforming building. It's that simple. That's all we're asking now. And that gets us absolutely nowhere, by the way. That gets us to first base so that we could come before you and all those other commissions, and with more defined and engineered plans and surveys, and then you could say yes or no. But at least we know that we've got some indication that we could have some type of residential and commercial on these properties that are really incapable of being developed as design commercial zone properties. I hope that clarifies it for you.
It didn't clarify it for me.
Not really.
No. I still don't see why any one of those other 25 uses are not applicable, and why we have to have residential.
So then what you're saying, Mr. Commissioner, is deny it. We'll wait another 10 years, the property go to rot again, and then we'll see what the next guy does with it. Is that what you really want as a zoning board of appeals? Or do you want to have enough common sense to say, let's work with this guy and get this place cleaned up and into productive property? Come on, it's not that hard.
My comment is about multi-unit residential, and I'm not in favor of that. What I'm seeing the regulations say is you can have a one residential unit perhaps. Let's look at the fine print. I feel very pressured here. Maybe it's because I'm getting late and I'm a little older. However, we have people come before the board for something with their own home in town, and it's so much more detailed. As Mr. Toulis pointed out, where's the engineers for the building? You know, there's a 105-year-old building. I was in buildings for a while. What, it's gonna fall down the next time you know. I'm just saying that. Just some comments. Hey, it's a bunch of.
Bob Shabbat, 17 Jared Sparks Road. Just like to make a point. Both of those buildings have had successful retail operations in them previously. So this idea of that they have to be changed so it's mixed use isn't necessarily true. They sustain retail businesses in the past. Why can't they sustain retail businesses into the future? Thank you.
Mr. Chairman, I'm sorry, is public comment still going? Because I obviously
Yes.
would.
Well,
Thank you.
One silly thing, an observation, my part. If I were to buy this truck, I'm very well. The one thing that I would do, because this goes back to, you can't talk about dollars, yet they want to bring up dollars. If I bought a piece of property, first thing I would want to do is an income survey on that property to know what I bought. Plain and simple. Anyone buying land should be doing, particularly in a rural community. So,
Thank you. Any other comments? I guess at this point, do we have any other questions from the board? No question? Questions? I would probably be more comfortable again with not closing the public hearing on this, because we've gotten a whole lot to chew on and think about, and I'm sure there's gonna be more questions. Hate to kick the can down the road, but
Mr. Chairman, if I might suggest something to kind of help procedurally, I still have very brief presentation for 335. The law, it's all the same as for 331. To get it into the record, would it make sense to present that to you now, or do you need to close, or since you're keeping this open anyway, would it make sense to open up 335 so we can get that on the record? I know it's late in the evening and
if we can run into that, what I'd be comfortable doing is continuing this public hearing. We got 2 minutes to take a vote, and then we could open up that. You could present. We don't have to, I don't know if we'd be going crazy into public comment, but because it's going to be very close to this.
Yes.
And chances, yeah, we'll go ahead. Okay. So I'd like to entertain a motion, ZBA 25-1, 331 River Road to
Continue the public hearing to February 12th.
I so move.
We have
I'll second.
Second, all in favor? Aye. Okay, now we'll go to ZBA 25-2, 335 River Road, public hearing for a variance request from 315-422, 315-504B, Table 5, 315-902A, 315-904, to allow for the creation of a mixed-use development containing 3 residential units, restaurant, not otherwise permitted in the zone. Zone design commercial. MBL 30-17-00 owner. Foundry LLC. Okay. I don't know if you want to say something, Mike, because you have, but.
Well, no, I just want to sort of mention, you're under no obligation to do anything with this now. And it makes no difference to me. I'm at meetings all the time to this hour, but if you're feeling like it's getting late and you've got a lot of information, obviously talk to the applicant, but you are within your timeframes. You could, since we're going to be here in February, you could just continue and deal with it all then.
I got a feeling we would have, but he wanted to make his presentation, and that way we can kind of think about that.
Sure.
Right along parallel with the other one.
Procedurally or statutorily, you have time. So, to his comment, don't feel that pressure to try to get all of it done today.
But it should open. We want to open it.
Yeah,
That was my point, just procedurally. Yep. So again, Rob Polito for the applicant. I'm just going to give you a very brief site description and history as to 335 River Road. It's developed in 1980. A gentleman named Rick Repko had his home there as early as 1997. The 1997 survey shows that Duncan and 335 were part of a single unified lot initially that was all owned by Rick Repko. So 1.14 acre lot. In fact, Rick Repko lived there and later converted the home into his design studio for Repko Antiques, as has been talked about. His home was demolished when Duncan acquired the 333 River Road and the parcel was subdivided. The current structure on 335 River Road was constructed on the previously installed foundation about between 1997 and 2004. So the property is about 22 years old. Our client purchased the property on April 19th, 22. 335 is also located again at the gateway to West Willington. It abuts Dunkin' Donuts at 333 and land owned by the Connecticut DOT. For the Foundry LLC, the applicant purchased the property to function as storage for antiques and a design studio for Repko Designs, which also owned 331. Again, as has been alluded to earlier, when my client purchased the property, it had been on the market for 10 years. It was completely abandoned. There were weeds and brush up to the second story. Poison ivy covered the entire outside of the building. There was graffiti. It was tick infested. I guess isn't a big deal here, but it still was tick infested. Again, there was a robbery there about 2 years ago, and the property was being used by various people as a dump site. We're blowing tractor trailer tires, miscellaneous metals, broken playground sets, and so forth. My client paid $135,000 for the property, spent about $37,000 to clean it up, made some minor interior improvements. And we already talked about the emergency repair to the septic. So the legal standards are the same as we talked about with 331, so I won't repeat that. I would just ask that that be, counsel, if that could be incorporated into the record for this hearing.
I don't see any reason why not. There's overlap in terms of the stuff that was discussed between the two. So
Okay.
Save time.
And then as to the hardship, again, it's similar arguments about hardship, but this one has one that's unique because of access to the property. The property is significantly set back from River Road and has no direct access from River Road. Its access is through the neighboring Dunkin' Donuts entrance. So that's something that's a little bit unique about this property as compared to 331. The lack of access alone eliminates most DC zone commercial uses which require high roadway visibility. Based upon these facts, the hardship requirement has been established. And again, as far as the regulations, POCD and neighborhood, the same arguments that we applied to 331 also apply to 335. It's getting late, so I'm going to stop there. And I know you guys have volunteered your time to be here, so I'll answer any questions, or we can move it along to next time.
I see a couple of hands up.
I'd like to express some comments about
This is Ralph Tools.
Ralph, can you move up? Because the mic's not going to pick it up.
You can start here, sir.
Okay. I think it was on the commission when welfare design got approved. And I was involved in the planning and zoning commission when Dunkin' Donuts was approved. That driveway that allows access from southbound Route 32 Dunkin' was an easement. It was supposed to have been an easement, but the understanding with the owner at that time that the unmerged lot was going to be available. So no direct access to Route 32 to me is wrong. That's bullshit, to be blunt. Okay, that's there. It was intended to be there. I don't know what the record shows, but that's what I recall from being very involved with the commission at that time. As far as that being a non-conforming lot, I'm not so sure. What's the area of the lot? Do we know? Well, my record shows that's about 1.18 acres.
Yeah, 1.18.
Well, that's over 40,000 square feet. That's a valid lot in a PC zone. So don't tell me it's a non-conforming lot. As far as the building, that building was built for Repco. on a new foundation. Or land. Not an existing foundation. I don't know anything about an existing foundation. There was residence there. But when the B and M owned that, they did a lot of playing around with things, dirt around and filling in so that they could ultimately sell it to them. I will not be able to be present for your 12th meeting. No, I'm not going to be able to make that meeting, so I won't get some. Well, the other.
Thank you.
Thanks, Ralph.
I'm saying. Second bullet. Okay. Yep. 7.
Thank you.
Are you getting? So we'll scan them. And
Or don't send it.
So they're marked.
I can get it. You only get one.
You'll have that.
Rob, do you need the copy of the other one? Do you need? No.
Thank
you. Mike, I can send you all three.
Okay.
Yeah.
Okay.
Mike's gonna scan them. Okay.
Yeah, we'll add them to the application portal so everybody can see them and the applicant has them.
Thanks, Mike.
John,
John Patton, Town Clerk, like Willington. I'm really confused with this request for a use variance. And the other variances, because it's no good for a commercial. So we want to leave a building and add another building that's residential. So we can put both a commercial and a residential on that property. And I'm sort of mixed emotions on this because I can guarantee you if this gets approved, I'm coming back for the property just to the north of it. Because it's sort of the Wild West at that point. Because we owned the Buggy House, which was built in like 1920, which is just to the north of this property. I get the DOT land in between, but it's making this request makes no sense to me. We have an existing building that we're being told is no good for a commercial, so we want to put a commercial business in there, but we also want to put residential. How is that a hardship? There is no hardship there. That's ridiculous. And so you as the ZBA are being asked to find a hardship so that you can do a use variance. Again, I don't know how you as the ZBA find a hardship for that. So the answer is pretty simple. It's got to be no, whether you like it or not. Thank you.
any other comments? Well, at this point, we'll continue the public hearing. Motion ZBA 25-2, 335 River Road. To continue it to February 12th.
At 7:30.
At 7:30.
So moved.
All in favor? Aye.
Sorry, I didn't.
Okay, approval of the minutes.
I will abstain those.
Do we have the three of us? Can we-
You don't need before for the minutes.
Okay. The approval of the minutes with
March 13th, 2025.
right here in the.
Wow. I tried to go, go full 12 months without you guys having it.
What that-
I've gone more than 12 months previously. It's got nothing, has nothing to do with my.
IR.
I have a faint recollection. I move that we accept those minutes. Can I do that?
I did.
Did. Second. Oh, you're not
I
second.
abstained.
Okay, all in favor? Aye. Okay,
I also move that we adjourn this meeting.
we have
Correspondence.
no correspondence. I think the public wants to leave. I don't think they want to participate in the end of the meeting.
Next to the entertainment. We did a motion for adjournment on the, we're adjourned. We're 10:39 p.m. Say it loudly for the recording.
10:39 p.m. We are adjourned.
Very cool. See you next month.
Thank you. Thank you for your input.
Thank you, I appreciate you.
That is that.
Our president, that's where it is.
We have a, she's the board, my partners is actually a, the board of trustees.
All right.
Yeah.